Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live legal educational content, and today may be the day I earn your subscription. For today's story, we are doing a follow-up, or a continuation, I guess, in our ongoing series, Supreme Court React, where we listen to oral arguments from the Supreme Court, try to divine the legal principles that are happening, and try to forecast any possible results based on the oral arguments. In today's case, we are doing Dobbs versus Jackson, Women's Health Organization. The facts of the case are this. In 2018, Mississippi passed a law called the Gestational Age Act, which prohibits all abortions with few exceptions after 15 weeks of gestational age. Jackson's Women's Health Organization, the only licensed abortion facility in Mississippi, and one of its doctors filed a lawsuit in federal district court challenging the law and requesting an emergency temporary restraining order. After a hearing, the district court granted the TRO while litigation proceeded to discovery. After discovery, the district court granted the clinic's motion for summary judgment and enjoined Mississippi from enforcing the law, finding the state had not provided evidence that a fetus would be viable at 15 weeks, and Supreme Court precedent prohibits states from banning abortions prior to viability. The U.S. Court of Appeals for the Fifth Circuit affirmed. Thus, the question presented, is Mississippi law banning nearly all abortions after 15 weeks of gestational age unconstitutional? So, of course, by way of background, we have Roe from 1973 and Casey versus Planned Parenthood from 1972 are the two major decisions on point in this arena. And now we have potentially the third in the series, which may overrule, modify, cancel, or do anything else to the prior two. So, like every 20 years or so, we have one of these things. So This is our third attempt, I guess, at this thing. So the issue squarely is confronting Casey versus Planned Parenthood. The idea of viability as a line comes straight from Casey versus Planned Parenthood in 1992. Roe versus Wade set up the trimester system. All abortions prohibited in the first trimester can be restricted in the second, can be banned in the third. But Casey versus Planned Parenthood redid the line at viability. So this is squarely contesting that idea from Casey versus Planned Parenthood, and of course potentially casting aspersions on Roe itself. So we are going to listen to this argument and try to determine what the Supreme Court is thinking, how it's reasonable, what the arguments look like, and we'll see how it goes. Everything. All right, let's get started with this. Come on, mouse. Damn it.
We will hear argument this morning in Case 19-1392, Dobbs versus Jackson Women's Health Organization. General Stewart.
Mr. Chief Justice, and may it please the Court, Roe versus Wade and Planned Parenthood versus Casey haunt our country. They have no basis in the Constitution. They have no home in our history or traditions. They've damaged the democratic process. They've poisoned the law. They've choked off compromise. For 50 years, they've kept this court at the center of a political battle that it can never resolve. And 50 years on, they stand alone. Nowhere else does this court recognize a right to end a human life. Consider this case. The Mississippi law here prohibits abortions after 15 weeks. The law includes robust exceptions for a woman's life and health. It leaves months to obtain an abortion. Yet the courts below struck the law down. It didn't matter that the law applies when an unborn child is undeniably human, when risks to women surge, and when the common abortion procedure is brutal. The lower courts held that because the law prohibits abortions before viability, it is unconstitutional no matter what. Roe and Casey's core holding, according to those courts, is that the people can protect an unborn girl's life when she just barely can survive outside the womb, but not any earlier when she needs a little more help. That is the world under Roe and Casey. That is not the world the Constitution promises. The Constitution places its trust in the people. On hard issue after hard issue, the people make this country work. Abortion is a hard issue. It demands the best from all of us, not a judgment by just a few of us. When an issue affects everyone, and when the Constitution does not take sides on it, it belongs to the people. Roe and Casey have failed, but the people, if given the chance, will succeed. This court should overrule Roe and Casey and uphold the state's law. I welcome the court's questions.
So right away, we're not hiding the ball in any way, are we? We are very clear about what we want. We're not hiding the ball, man. We want to overrule Roe and we want to overrule Casey. So he says this doesn't have a history in our traditions. This would be going, of course, back to English common law and the idea of that. So there's no really robust history, and there's certainly no constitutional text that explicitly contemplates it. And even Ruth Bader Ginsburg was critical of Roe as not being well based in the Constitution. She upheld it from policy reasons, but even Ruth Bader Ginsburg was critical of its reasoning because it's hard to find a constitutional hook. So he's like, well, this isn't something that the Constitution protects. It's not something well established in our English common law history. And any issue the Constitution does not speak to is an issue left for the legislature. So if it doesn't speak to the issue, it's an issue for policy, and the people decide what is the right thing in terms of hard issues. So he says, this should be a legislative issue. Let the people speak. Maybe, let them vote, and whatever happens. It's not something for the Constitution. So he's, not hiding the ball. So pretty clear.
General Stewart, you focus on the right to abortion, but our jurisprudence seems to focus on, in Casey, autonomy, in Roe, privacy. Does it make a difference that we focus on privacy or autonomy, or more specifically on abortion?
I think whichever one of those you're focusing on, Your Honor, particularly if you're focusing on the right to abortion, each of those starts to become a step removed for what's provided in the Constitution. Yes, the Constitution does provide, protect certain aspects of privacy, of autonomy, and the like. But as this court said in Glucksberg, going directly from general concepts of autonomy, of privacy, of bodily integrity to a right is not how this court traditionally does due process analysis. So I think it just confirms whichever one of those you look at, Your Honor, a right to abortion is not grounded in the text, and it's grounded on abstract concepts that this court has rejected in other contexts as supplying a substantive right.
You say that this is the only constitutional right that involves the taking of a life. What difference does that make in your analysis?
Sure, Your Honor. I think it makes a number of differences. One, I mentioned two in particular. One is it really does mark out the unbelievably profound ramifications of this area, which in many other areas, assisted suicide, a whole host of important areas that are important to dignity, autonomy, freedom, and important to matters of conscience. It marks it out as one of the unique areas where this court has taken that important issue to the people, and it's something that implicates life, and it just, I think, marks off, Justice Thomas, how problematic and unusual and how much of a break the court's abortion jurisprudence is from those other cases.
If we don't overrule Casey or Roe, do you have a standard that you propose other than the viability standard?
It would be, Your Honor, a clarified version of the undue burden standard. I would emphasize, I think, as Your Honor is alluding to, that no standard other than the rational basis review that applies to all laws will promote an administrable, workable, practicable, consistent jurisprudence that puts matters back with the people. I think anything heightened here is going to be problematic, but I would say if the court were not inclined to overrule Casey, the choice would be undue burden standard, untethered from any bright line viability rule.
Thank you.
Well, I'd like to go to a different topic, back to Casey.
Yes,
I assume you've read Casey pretty thoroughly.
Yes, Your Honor.
And there are two parts. One is they reaffirm Roe. Put that to the side. The second is an opinion for the court, not for three people, but for the court. And that second part is about what stare decisis principles should be used to overrule a case like Roe. And they say Roe's special. What's special about it? They say it's rare. They call it a watershed. Why? Because the country is divided, because feelings run high, and yet the country, for better or for worse, decided to resolve their differences by this court laying down a constitutional principle, in this case, women's choice. Right? That's what makes it rare. That's not what I'm asking you about. I want your reaction to what they said follows from that. What the court said follows from that is that it should be more unwilling to overrule a prior case. Far more unwilling we should be, whether that case is right or wrong, than the ordinary case. And why? Well, they have a lot of words there, but I'll give you about 10 or 20. There will be inevitable efforts to overturn it. Of course there will. Feelings run high. And it is particularly important to show what we do in overturning a case is grounded in principle and not social pressure, not political pressure. Only, quote, the most convincing justification can show that a later decision overruling, if that's what we did, was anything but a surrender to political pressures or new members. And that is an unjustified repudiation of principles on which the court stakes its authority. And then there are two sentences I'd like to read, because they say they really mean this, the court, not just three. To overrule under fire in the absence of the most compelling reason to re-examine a watershed decision would subvert the court's legitimacy beyond any serious question. And the last sentence, after they quote Potter Stewart on the same point, they say overruling unnecessarily and under pressure would lead to condemnation, the court's loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function as the Supreme Court of a nation dedicated to the rule of law. Now, that's the opinion of the court. All right? And it's about stare decisis and how we approach it. And I hope everybody reads this. It's at 505 U.S. 854 to 869. All right. What do you say to that?
Now, I do like this question from Breyer. And I have many criticisms of the man, as we all know. But I like this question because it goes to the issue of stare decisis, and it also goes to the issue of the legitimacy of the Supreme Court as a legal branch rather than as a political branch. So let's deal with those in turn. So stare decisis just means a thing decided. It's the idea that once something is decided, it should stay decided. We just shouldn't be rehashing the same issues all the time. We should, deal with new issues. We shouldn't rehash the old issues. Now, of course, no one thinks that stare decisis should be an absolute principle because, there's been some pretty notable decisions that have needed to be modified. Plessy versus Ferguson comes notably to mind. Dred Scott comes notably to mind. And there are other decisions which need to be reversed. And no one thinks it's an absolute principle. The concept of stare decisis as such is a concept that goes well back into English common law. So it's not like something that our Constitution invented. So the degree to which stare decisis is built into our Constitution implicitly by the very nature of us adopting a judicial system based on English common law is obviously a thing that is at least colorable as a discussion point. Now, of course, the contrary to that is that if the Supreme Court makes the wrong decision, they've effectively amended the Constitution without amending the Constitution, which obviously the Supreme Court can't do. But the contrary to that is that if we're always reevaluating, then there's no stability. and we're always worried about the balance of the court, and we're never firm about anything. So it's, you know, there's a common phrase to express this dual tension. The law should be predictable but never stand still. Law should be predictable that never stands still. Stare decisis as a concept makes things predictable, because regardless of whether you agree with any particular decision or not, and you can criticize decisions for any number of reasons, as I sometimes do, the fact that the decision is baked in or is followed makes it very easy for me, for example, as a lawyer, to give good advice. Because I'm like, well, you know, I know the answer because the Supreme Court decided this, you know, so I can give you the answer. I can have my quibbles or my misgivings, but it's very easy to give good predictable advice because of stare decisis. So stare decisis isn't necessarily a bug. It's a feature. How much of a feature it should be is a bit of a question. So there's that. Then the second issue that Breyer raises is that the United States judiciary is not a political branch. The executive and legislative are political branches, but not the judiciary, which is a legal branch, and is supposed to decide things based on law, not politics. And obviously the people that are at the Supreme Court are chosen politically by certain legal views, but, you know, it's important to keep those things separated, both in reality and as a perception. Again, a common idea is that justice must be done and seen to be done. You know, things must be just in fact, and also they must be seen to be just. If things are not seen to be just, even if they're just in reality, it leads to, you know, all kinds of problems, including undermining of the confidence. So he's like, well, how do we avoid these problems? And as he points out quite right, in Casey versus Planned Parenthood, in a majority decision, because it was fractured, but there was a part that was majority decided, and that part was written by Justice O'Connor, talks about when and how to overrule precedent. And it's as good as explanation as anyone's ever put to pen to paper. So you don't have to agree with it. You don't have to think it's the end all be all, but it was, you know, as good a thorough an explanation as, you know, you could reasonably write. And for example, Justice O'Connor said, well, here's some things, like if the precedent has been so undermined by other cases that it's basically become unsustainable. So, like, you're right, you have exceptions in cases, and the idea is that you cut so many holes that the underlying rule disappears, right? That so the case should just disappear because it's not, you know. Another one would be sufficiently large changes of fact, right? If it's based on factual understandings and there's sufficient development of facts, maybe that's a reason. Another reason would be because it's proven to be unworkable. You know, we've had this standard, we've tried to apply it, we've tried, and we just failed. It just has failed. So this standard, it's just been unworkable, it's been unmanageable. We can't make it work, so let's get rid of it because we need to come up with something better. And there's a fourth one, which I can't remember off the top of my head. But yeah, that was Justice O'Connor writing for majority of the Supreme Court. And so he's basically saying, well, you know, this was part of the majority decision on this, and so, you know, shouldn't we? And as he notes that, you know, only the most, you know, significant reasons should, at least in O'Connor's view, only the most significant reasons should allow for a decision to be overturned, because otherwise you have a situation where, you know, things look political, even if they're not political, and in any case, it becomes very hard to predict what the development of the law should be. So he's asking a very, very good question. It's a very important question. You can disagree with stare decisis. You can even disagree with it completely if you're so inclined. I mean, I just point out that it's, you know, part of the common law tradition that goes well back, but I mean, you could disagree with it as a concept. It'd be a little bit hard to think that stare decisis should always be true. That'd be a difficult position. You could plausibly think it should never be true, but as I point out, it leads to a whole bunch of collateral consequences. But, he's raising some real important questions, regardless of what you think the answers are. So let's see what the answers are.
Sure, Justice Breyer. I would say a couple things. I would say we have very closely gone through the factors that the Casey court itself went through in stare decisis. More than half of our brief is devoted to stare decisis. We now have 30 years in the wake of Casey to see what Casey has done and what it hasn't done.
Well, it's got some bad things in the eyes of some people and some good things in the eyes of some people.
Your Honor.
All right, go ahead.
I'm sorry, Your Honor. What I'd emphasize, Your Honor, is that to the extent that I would not say it was the people that called this court to end the controversy. The people, many people vocally really just wanted to have the matter returned to them so that they could decide it locally, deal with it the way they thought best, and at least have a fighting chance to have their view prevail, which was not given to them under Roe and then as a result under Casey. And I'd also emphasize, Your Honor, that on stare decisis, just as I said, the last 30 years, workability, developments in the law, factual developments that states can't account for, the workability, the undue burden standard alone, many problems. On all the metrics that Casey was describing, or the vast bulk of them, Casey fails. And I'd also emphasize this as well, Justice Breyer, that Casey was not was not a great example of simply letting precedent stand. It recast Roe's reasoning. It overruled two of the court's most important abortion decisions. It jettisoned the trimester framework of Roe itself and adopted a new standard unknown to other parts of the law. Those are not the hallmarks of precedent, and they failed under this court's stare decisis.
Okay, can I?
No, that's a good answer. I mean, you had to see this question coming, right? I mean, you see this question coming from a mile away. As they pointed out, they spent half their brief on it. So, this question's coming, so you have a really good answer for it. So he has a really good answer for it. He's like, well, a couple things. First of all, unworkable. It's proven to be unworkable. We haven't been able to apply this. There have been really huge changes in facts, medical understanding, sonograms, 3D sonograms, genetic information, the ability to crack the DNA code from computers and so forth. So there's been major changes in underlying factual reality. And then he points out, with a nice little clever twist, that it's not really a great example, because even in that case where they're saying you should be really, really careful about overruling precedent, they were overruling precedent because they abandoned the framework. So they basically gutted the major part of Roe, which is not wrong. So, it's a smart answer. It's what you'd expect.
Take it that your answer is, yes, you accept the special rule, the rule for the rare watershed.
And I'll just give a little, note for the chat here. I don't care if you're pro-choice or you're pro-life. The moderator should not be discriminating on that basis. What I do care about is if you're rude, especially to other people in the chat. You can express differences of opinion, but don't make them personal. If you make them personal, you're going to have a bad time. Okay? So, there's your warning for the day.
The stare decisis principles for deciding whether to overturn such a case as Roe, you accept that, and you think it's met.
I would say yes, in part, Justice Breyer, and here's what I'd emphasize, is that I do think, particularly when Casey looked outward and looked to what it saw as pressure, there were pressure on all sides. As Your Honor noted, this is a hot, difficult issue for everyone. That's why it belongs to the people. And I think the conclusion the court drew from that it couldn't provide a good enough example, that it would look unprincipled, those conclusions were, with respect, Justice Breyer, mistaken. And the last 30 years has not seen any calming of that. It's been very different than some of the court's other controversial decisions that have seen much more calm.
What hasn't been at issue in the last 30 years is the line that Casey drew of viability. There has been some difference of opinion with respect to undue burden, but the right of a woman to choose, the right to control her own body, has been clearly set for since Casey and never challenged.
This is a kind of a good question, actually. So I'll break to discuss this briefly. Roxham in chat says, where was stare decisis in Quill Court versus North Dakota, wherein the Constitution does allow a court to make someone in one state a tax agent of another? So that's a very good question. So the precedent that Quill Court versus North Dakota overturned, for those of you who are might not familiar with it, is it dealt with mail-in catalogs, when that was the dominant way that business was done between states. This long precedes the internet, long precedes modern communications. So back when, there was the Sears catalog, the rule was no sales tax if the business didn't occur in that state. So if you ordered something from one state and the place you ordered it from didn't have sufficient connection to that state, so they didn't have a warehouse or they didn't have a distribution plant or it wasn't manufactured there, blah, blah, blah. But if it didn't have sufficient connection, you didn't have to pay sales tax on it. Incidentally, in most of those states, you had to pay a use tax, but no one ever did. But anyways, I digress. Anyways, fast forward many, many moons later, and well, if you go to, for example, Casey versus Planned Parenthood and when you should overturn things, there was there was a massive change in fact. Right? There's a massive change in fact. Suddenly we have the internet and like everything's being ordered online, cars and all the rest of it. It's like, so a massive percentage of business is being done. It's like, well, that kind of changes things radically. So, they can collect sales tax in your business because, now that we're going to say, well, the place of sale is where you bought it. Because effectively, kind of is. We just have to choose one, right? So it's like, yep, that would be the rationale, right? Every state is sovereign. Every state has the right to choose to charge sales tax if they want. And so they said, well, there's just been a massive undertaking in fact, because, internet. So I don't know if that's helpful to your question, but it's a good example of precedent and changes in facts and why you might overturn cases.
You want us to reject that line of viability and adopt something different. 15 justices over 50 years have, or I should say 30 since Casey, have reaffirmed that basic viability line. 4 have said no, 2 of them members of this court, but 15 justices have said yes, of varying political backgrounds. Now, the sponsors of this bill, the House bill in Mississippi, said we're doing it because we have new justices. The newest ban that Mississippi has put in place, the 6-week ban, the Senate sponsor said we're doing it because we have new justices on the Supreme Court. Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts? I don't see how it is possible. It's what Casey talked about when it talked about watershed decisions. Some of them, Brown versus Board of Education it mentioned, and this one, have such an entrenched set of expectations in our society. This is what the court decided, this is what we will follow. That we won't be able to survive if people believe that everything, including New York versus Sullivan, I could name any other set of rights, including the Second Amendment, by the way. There are many political people who believe the court erred in seeing this as a personal right as opposed to a militia right. If people actually believe that it's all political, how will we survive? How will the court survive?
Justice Sotomayor, I think the concern about appearing political makes it absolutely imperative that the court reach a decision well-grounded in the Constitution, in text, structure, history, and tradition, and that carefully goes through the stare decisis factors
Casey
we've laid
did
out.
That.
No, it didn't, Your Honor,
Casey went
respectfully.
through every one of them. You think it did it wrong. That's your belief. But Casey did that.
Well,
and you haven't added
Your Honor.
much to the discussion in your papers as to the errors that Casey made, other than I disagree with Casey?
Justice Sotomayor, maybe I can highlight two. Casey gave one paragraph to the workability of Roe. It then adopted the undue burden standard, which is perhaps the most unworkable standard in American law. It gave about 3 paragraphs, if memory serves, to reliance, which doesn't account for the last 30 years and the changes that have occurred since Casey. It gave a brief factual view to things that have changed since Roe. Those, of course, are not going to take account of the last 30 years of advancements in medicine, science, all of those things.
What are the advancements in medicine?
I think it's an advancement in knowledge and concern about such things as fetal pain, what we know the child is doing and looks like and is fully human from a very early...
In regular cases, courts decide whether science fits the Daubert standard. Obviously, under the Daubert standard, the minority of people, a gross minority of doctors, who believe fetal pain exists before 24, 25 weeks. It's a huge minority, and one not well founded in science at all. So I don't see how that really adds anything to the discussion. That a small fringe of doctors believe that pain could be experienced before a cortex is formed doesn't mean that there's been that much of a difference since Casey.
We pointed out as an example, Your Honor, of where Roe and Casey improperly preclude states from taking account for these things, and they should be able to be concerned about a fact of an unborn life being poked and then recoiling in the way one of us would recoil.
General, I know what it said about viability in Roe, but was viability an issue in the case? I know it wasn't briefed or argued.
It was not an issue certainly the way it is an issue here, Your Honor. I think it was, to the extent that the court had to reaffirm Roe. The way to read that as something other than dicta would be to understand.
I'm sorry. I don't know what that said. Was it an issue in Roe?
Oh, in Roe?
Yeah.
I'm sorry, Your Honor. My understanding is no. I mean, the law there was didn't have a viability tag. That was inserted by.
In fact, if I remember correctly, and it's an unfortunate source, but it's there. In his papers, Justice Blackmun said that the viability line was dicta, and presumably he had some insight on the question.
Now that's a nice little factoid there. From Justice Blackmun, from his papers after he died. His papers became available, and Justice Blackmun said, hey, that thing that we said about viability, actually that was dicta. That wasn't part of the binding decision, which is kind of unintentionally hilarious, because that, along with undue burden, like if you want to summarize what Casey versus Planned Parenthood said, you need to know two things: viability, undue burden. That's what Casey versus Planned Parenthood said. Viability, undue burden. The rest is just filler. And according to Justice Blackmun, at least one of those two things was just dicta that shouldn't really count, which is unintentionally hilarious.
I think, and I'd add, Your Honor, Justice Blackmun, in I think as well his papers pointed out the arbitrary nature of it. And
I didn't explain it for people who are new to the channel. I apologize. Dicta is part of a decision that is non-binding. So you have an otherwise binding decision, but you have parts of it that are non-binding. And the typical test of whether something's dicta or not is whether or not that thing is necessary to the result, right? So you might as you're writing a decision, on one topic for, reasons of train of thought, you might start talking about other things, because, for example, you might want to analogize it to a different thing, or you might want to say, well, here's how we reason in some other area, or here's how other rules and other contexts apply. So you might start musing about other subjects unrelated to the core subject. And as you're kind of doing that, those things are, when you're describing those things, those aren't holdings of the case, even if there's a majority decision. So even if like it's 9-0, if you find something that's like contradictory from a prior case, it doesn't really count, because that's an example. It's parts of a case that are non-binding. That's dicta.
And the line drawing problems in there too.
And then in Casey said that was the core principle or the central principle in Roe, viability. It said that after tossing out the trimester formula, which many people thought was the core principle. But was viability at issue in Casey?
I don't think it was squarely at issue, Your Honor. Again, it's a little hard not to take the court at its word when it emphasized that viability is the central part of Roe's holding, and saying that it is reaffirming that. So we kind of take that as it stands, but the court has not. It did not face a law like this, certainly, Mr. Chief Justice.
May I finish my inquiry?
Of course, Justice Sotomayor.
Virtually every state defines a brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness. So I go back to my question of what has changed in science to show that the viability line is not a real line, that a fetus cannot survive. And I think that's what both courts below said, that you had no experts say that there is any viability before 23 to 24 months.
And what I'd say is this, Justice Sotomayor, is that the fundamental problem with viability, it's not really something that rests on science so much. It's that viability is not tethered to anything in the Constitution, in history, or tradition. It's a quintessentially legislative line. A legislature could think that viability makes sense as a place to draw the line, but it's quite reasonable for a legislature to draw the line elsewhere.
There's so much that's not in the Constitution, including the fact that we have the last word. Marbury versus Madison. There is not anything in the Constitution that says that the Supreme Court, is the last word on what the Constitution means.
I laugh at this line. I laugh at this line because very recently, Nick Rekieta and I had a discussion, a very polite discussion, on whether Marbury versus Madison was correctly decided. You know, is the concept of judicial review in there? Nick says no. I say yes. I say, yeah, it is part of the Constitution. As far as I'm concerned, it's in the text. I tried to explain my reasoning, and we had a nice little discussion about it. We didn't come to consensus. It was great. So Justice Sotomayor also says I'm wrong, which is kind of hilarious. But then again, it's Justice Sotomayor, so, you know, yeah. But anyway, she says I'm wrong. She says that judicial review and the ability of the Supreme Court to do what it does isn't in Article 3. So I laugh because, you know, I basically had this discussion with Nick like 2 days ago.
It's totally novel at that time. And yet what the court did was reason from the structure of the Constitution that that's what was intended. And here in Casey and in Roe, the court said there is inherent in our structure that there are certain personal decisions that belong to individuals and the states can't intrude on them. We've recognized them in terms of the religion parents will teach their children. We've recognized it in their ability to educate at home if they choose. They just have to educate them. We have recognized that sense of privacy in people's choices about whether to use contraception or not. We've recognized it in their right to choose who they're going to marry. I fear none of those things are written in the Constitution. They have all, like Marbury versus Madison, been discerned from the structure of the Constitution, why do we now say that somehow Roe versus Roe and Casey are so unusual that they must be overturned?
Well, Justice Sotomayor, I would emphasize two things. When you're going beyond the Constitution, this Court has looked closely to...
No, what I'm saying is they didn't go beyond the Constitution.
Your Honor, they did not deduce those from the structure of the Constitution. They pointed to the 14th Amendment and reasoned that privacy in Roe, autonomy and similar values in Casey led to a right to abortion. That's not how this Court traditionally does things, including in the vast run of cases that Your Honor ran through. The Court looks to history and tradition, and here those decisively reject the proposition that states cannot legislate comprehensively on abortion before, after viability, and all throughout. So it's history and tradition, Your Honor. And I would also add, Your Honor, that those decisions, a great many of them draw, not just draw from text, history, and tradition, but they draw often clear lines, very workable, have not led to the many negative stare decisis factors that we identify here.
General, go ahead. Go ahead, Justice Barrett. Would a decision in your favor call any of the cases, that Justice Sotomayor is identifying into question?
Okay, so this is a good question from Barrett. This is a very good question from Barrett. What are the limiting principles? What are the limiting principles of your decision? He says that Roe and Casey are not part of our history, tradition, structure. They're just kind of divined out of the ether. And they've been talking about some other cases, like, for example, Griswold versus Connecticut, which talks about the right of married people to have contraception. And she asked the question, okay, it's like, well, if Roe and Casey are wrong because there's nothing in the Constitution that seems to require it, or history, tradition, then it would seem like, most contraceptives would have to fall for the same reason. Those weren't particularly well known at the time of the founding. So do those cases get overruled as well? Are we looking at overruling a fair chunk of jurisprudence if we go down this road? So is it a limited principle or not? It's a good question.
No, Your Honor. I think for a couple reasons. First of all, I think the vast run of those cases, and some mentioned from time to time, I think Griswold, Lawrence, Obergefell, these are cases that draw clear rules. You can't ban contraception, can't ban intimate romantic relationships between consenting adults, can't ban marriage of people of the same sex. Clear rules that have engendered strong reliance interests and that have not produced negative consequences or all the many other negative stare decisis considerations we pointed out, Your Honor. Also, I'd add, none of them involve the purposeful termination of a human life. So those two features, stare decisis and termination of a human life, Your Honor, puts all of those safely out of reach if the Court overrules here.
Okay, I mean, this answer is a little unsatisfying. I don't know that he has anything better. It's a little unsatisfying, but he says, okay, if you go to like Obergefell, which deals with gay marriage, if you go to Griswold versus Connecticut dealing with contraception, if you go to some of these other cases, he says, that these rules have been proven, these rules have been workable. They haven't resulted in any chaos or problems. We've been able to apply these standards, and it hasn't been an issue. So there's not those other considerations like with those cases. So there's not the chaos that's come from undue burden, which, fair. And then he says that that the other thing was that the fact that this terminates human life makes it different. So this is the only issue that results in a human being, which, regardless of how you think about abortion, I mean, a fertilized egg is human. I mean, what else could it possibly be? It's not a dolphin, right? It's human. It has, when it's fertilized, it has its own DNA patterns, and it's a human DNA, and so it might be one cell big, but it's human. Whether or not that qualifies it for protection under law, of course, is a whole different set of problems. But it's human. What else could it possibly be, right? So it's like, well, this terminates humans. So that's a problem. It's not the most satisfying answer because it's a little cagey, because like the intellectually pure thing to do here would be to go, well, I don't know so much about gay marriage though, because I think you can attack that from different grounds. I didn't really like Kennedy's decision. I thought it was badly based. But I thought you could have decided on a rational basis grounds. There's no rational basis because every argument that you try to put in favor of it just falls apart. It doesn't work. So I think you could have gone there from other means. But Griswold would be attackable. So, yeah, I mean, it's not the greatest answer. I don't know that there's anything better if he wants to stem the tide, though.
Okay, so I'm sorry to interrupt again, but we really might be making progress. I mean, in the part that I read, of Casey,
Yes, Your Honor.
I think they go back 150 years. Maybe now we could go back 200. They think there have only been 2 cases, which were what they call the watershed, and where these special tough overruling rules apply. You want this to be the 3rd, or do you think there were more? And if so, what were they?
Well, Your Honor, I think there's quite a bit of difference. I think the question is never, is it bad to overrule, period? Surely sorry.
I'm asking you to think in their terms. There were 2 they mentioned, you see. And they don't want Casey they don't want Roe to be the 3rd. And now, in your opinion, you just answered Justice Barrett, hey, all these are not rising to that level. Okay?
Right.
Are there any that do rise to the level, in your opinion?
I think, and I'm not sure that I necessarily agree with the watershed characterization, Your Honor. What I'd say, though, I can't think of another that kind of hits the radar, but I'd emphasize that a problem here is we're dealing with a right that doesn't have a basis in constitutional text, and again, very much in conflict with those values, Justice Breyer.
I'm not sure how your answer makes any sense. All of those other cases, Griswold, Lawrence, Obergefell, they all relied on substantive due process. You're saying there's no substantive due process in the Constitution, so they're just as wrong according to your theory.
No, Your Honor, we're quite comfortable with Washington versus Glucksberg and how it analyzes substantive due process, and it looks to text history. It looks to history and tradition to discipline the inquiry and make sure.
I mean, in Obergefell, there was no history of same-sex marriage.
And I think the court pointed out, look, when we were facing Loving versus Virginia.
I'm not trying to argue that we should overturn those cases. I just think you're dissimulating when you say that any ruling here wouldn't have an effect on those.
Respectfully, that's.
Do you think that no state is going to think otherwise? That no people in the population aren't going to challenge those cases in court?
I mean, Your Honor, we'll always have a diversity of views, but I think
that's the point.
I think that's one of the benefits of our society.
Isn't that the point?
That there's a diversity of views and people can vigorously debate and make decisions
exactly,
themselves.
and that's what we're still doing, and that's what we're doing under undue burden, but we haven't been doing it on the viability line.
And neither one has worked well. The viability line discounts and disregards state interests, and the undue burden standard has all of the problems that
How
we
is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time.
You gotta love that. You gotta love that. When someone asks the question and then immediately answers their own question. You just gotta love that. Someone asks a question, then immediately answers their own question. How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. Yeah.
It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect a life, that's a religious view, isn't it? Because it assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor, aside from
I'm putting it aside from religion.
I'll try to. I think there might be more than one question, and I'll do my very best, Justice Sotomayor. I think this court in Gonzalez pretty clearly recognized that before viability, we are talking with unborn life with a human organism. And I think the philosophical questions Your Honor mentioned, all those reasons that they're hard, they've been debated, they're important, those are all reasons to return this to the people, because the people should get to debate these hard issues. And this court does not in that kind of a circumstance.
So when does the life of a woman and putting her at risk enter the calculus? Meaning, right now, forcing women who are poor, and that's 75% of the population, and much higher percentage of those women in Mississippi who elect abortions before viability, they are put at a tremendously greater risk of medical complications and ending their life, 14 times greater to give birth to a child full term than it is to have an abortion before viability.
First of all, I question that statistic 14 times. And second of all, when you're multiplying a really, really, really small number by 14, it still is a really, really small number. So even assuming it is 14, which I dispute, it's so rare that, it's probably not really much practical difference. So a little bit deceptive in my view of a question.
And now the state is saying to these women.
Yeah. So, yeah, this is interesting, too. So, because someone in chat pointed this out, and I kind of missed it. I'm glad you pointed it out because I wanted to comment on it. She says, forcing women who are poor, and it's about 75% of the population, and much higher percentage of those women in Mississippi. So, I'm not sure if she's saying 75% of all people are poor, or she's saying 75% of specifically women are poor, and a much higher percentage of those in Mississippi. But, either way, whether she's talking about all people or just women, 75% of the population is poor. What?
We can choose not only to physically complicate your existence, put you at medical risk, make you poorer by the choice, because we believe what? That
Sure, Your Honor. I think to answer, I think the question I think you led with, and then I think it expanded on, but is still on the same issue, is as to when does a woman's
Alexander in chat offers she means 75% of women that get pregnant. I continue to dispute this, Alexander. I dispute that 75% of women who get pregnant are poor. That seems very implausible to my mind.
Interests enter, as far as we're concerned, it's there the entire time. Our point is that all of the interests are there the entire time, and Roe and Casey improperly prevent
75% of those seeking abortion? Maybe. I mean, possible. I wouldn't know for sure. It sounds pretty high to me, but at least it's not patently absurd off the top of my head. So, I don't know, but yeah, I would question even that, although it's not quite as ridiculous. Maybe it's like maybe I'll look into it half a step before I dismiss it.
States from taking account and weighing those interests however they think best. We're not saying
General, are there secular philosophers and bioethicists who take the position that the rights of personhood begin at conception or at some point other than viability?
I believe so. I mean, I think there's a wide array, of people of kind of all different views and of no faith views who would reasonably have that view, Your Honor. It's not tied to a religious view, and I don't think, were it otherwise, this Court's jurisprudence on this issue would run right into some of its religious exercise jurisprudence.
General, Justice Breyer started with stare decisis, an important principle in any case. And here, for the reasons that Casey mentioned, especially so, to prevent people from thinking that this court is a political institution that will go back and forth depending on what part of the public yells loudest, and preventing people from thinking that the court will go back and forth, depending.
75% of minority women, Jacob offers. Well, if we continue to constrict our use cases tighter and tighter, so 75% of minority women who are seeking abortions before viability are poor. Maybe that's the answer. I mean, we've constricted our population so tight, but yeah, maybe that's the answer, but still, 75% of minorities. I don't know, man. That still seems high to my mind, but at least we're getting more and more plausible by restricting our data set.
On changes to the court's membership. And what strikes me about this case, and you come here very honestly, saying, we want you to discard the entire setup, and then even if you don't do that, we want you to discard the viability line, which you've acknowledged again today. Casey says is the heart, the central principle of Roe. And so usually there has to be a justification, a strong justification in a case like this, beyond the fact that you think the case is wrong. And I guess what strikes me when I look at this case is that, not much has changed since Roe and Casey. That people think it's right or wrong based on the things that they have always thought it was right and wrong for. So the rationale behind those cases has something to do with the autonomy and the freedom and the dignity of women to pursue their lives as they wish, to protect their bodily integrity, to make the decisions that are most fundamental to the course of their lives. And always in those cases, there was an understanding that there were important interests on the other side in protecting life or protecting the potential for life, whether people saw it one way or the other way, and that there was a difficult question here and a balance to be made. And, it strikes me that some people think those decisions made the right balance, and some people thought they made the wrong balance. But in the end, we are in the same exact place as we were then, except that we're not, because there's been 50 years of water under the bridge, 50 years of decisions saying that this is part of our law, that this is part of the fabric of women's existence in this country, and that places us in an entirely different situation than if you had come in 50 years ago and made the same arguments. So I guess I just wanted to hear you react to that.
Of course, Justice Kagan, thank you. I would emphasize a couple things, Your Honor. The fact that so much time has passed, let's say nothing had changed. That's not a point in Roe and Casey's favor. They have no basis in the Constitution. They adopt a right that purposefully leads to the termination of now millions of human lives. If nothing had changed, they'd be just as bad as they were 30 years ago, 50 years ago. And now we just have decades of damage, and we have a situation where nearly 30 years after Casey, the court unfortunately divides over what Casey, the lead case in the abortion area, even means. The lower courts are left not knowing what to do, as I think kind of a fundamental problem here is, I think, as Justice Gorsuch mentioned, emphasized in his opinion in June Medical, that the problem for lower court judges is the Constitution doesn't give them an answer to this. There's no neutral rule of law, so judges unfortunately have to look within themselves, and that's just never going to solve this issue. But if the matters return to the people can deal with it, they can work, they can compromise and reach different solutions. But if we don't do that, we're just going to have all this sort of damage, and at some point it's appropriate for the court to say enough, as it has in some of the great overrulings, in Brown and in other cases where it said this is just enough. Justice Harlan had it right in dissent in Plessy when he recognized that all are equal, and similarly here, the state should be able to recognize, hey, there are real values on both sides here. We think that this one slightly outweighs. We think that this one slightly outweighs, or we think that there's some balance to be drawn here. But if the court doesn't do that, Justice Kagan, it's just going to be continued damage, and the court will continue to plunge in this political issue. I apologize, Mr. Chief Justice. I've gone over.
No, that's all right. I have just a few little, well, not little, I hope, questions. And the first gets back to the issue of viability. In your petition for cert, your first question, and the only one on which we granted review, was whether all pre-viability prohibitions on elective abortions are unconstitutional. And then I think it's fair to say that when you got to the brief on the merits, you kind of shifted gears and talked a lot more about whether or not Roe and Casey should be overruled. And I wanted to give you a chance to explain that.
Sure, Your Honor. So a couple points. At the petition stage, we were, of course, we identified for the court 3 questions. We emphasized, as you do at the cert stage, hey, this is important. Only this court can resolve it. We emphasized, I believe it was 5 times, that the court was at the least going to need to reconsider, revisit, or reevaluate its precedents. And we asked the court to at least get rid of a viability line or any suggestion of a viability line. So we added, however, and we had to take account of the reality that this argument has not fared well in the lower courts. It's lost in every court of appeals. So, we raised the issue in addition, but once the court granted only the first question, we presented every argument as we, signaled we would present the full-blown constitutional merits argument with that fundamental question. So I'd emphasize that, Your Honor. It was kind of the shift. You go from cert stage to merit stage. The court granted one question. That question fairly includes what is the correct standard?
It fairly includes the broader arguments you raised. I'm not suggesting that. But on the other hand, it presumably included the viability question as well, because that's what you talked about in that one sentence.
And we've addressed that as well, Your Honor. What I'd emphasize here is that the merits arguments of, the validity of Roe and Casey as an original matter, is there a viability rule based in the Constitution? Those are not that complicated or lengthy. The harder questions are, should the court overrule and take that momentous step? And that's why we devote a lot of space to that very important issue. We respect stare decisis and have walked through all those points. But again, focusing on the question presented and presenting our best arguments for that, that's what we've done, Mr. Chief Justice.
On stare decisis, I think the first issue you look at is whether or not the decision at issue was wrongly decided. I've actually never quite understood how you evaluate that. Is it wrongly decided based on the legal principles and doctrine when it was decided, or in retrospect? Because Roe, there are a lot of cases around the time of Roe, not of that magnitude, but the same type of analysis that went through exactly the sorts of things we today would say were erroneous. But do we look at it from today's? If we look at it from today's perspective, it's going to be a long list of cases that we're going to say were wrongly decided.
Okay, another good question going to what is the logical impact of this, right? What is the logical impact of this decision? Which is a perfectly fair question to raise. So he says, okay, when we're deciding something is wrong, should we say based on whether it was wrong at the time or based on retrospect? And he points out quite correctly, there's quite a few cases at the time that were analyzed under similar lines and have similar problems. And he says, well, if we're going to do this based on the standards today, we're going to have to overrule a whole bunch of case law, which, might be the correct answer, I suppose. But he's asking him, is that the correct answer? Or is this more limited? So why? It's a good question.
Well, I'd say, Mr. Chief Justice, that you can look both. Was it wrong at the time? Has it been unmasked as wrong by new understandings, new knowledge, and any developments? But I don't think, as I think my colloquy with Justice Barrett indicated, the court won't have to be looking at many other areas, because this is an area that has a uniquely problematic set of stare decisis considerations. A lot of other controversial areas, or once controversial areas, are quite settled, clear rules, and don't have those considerations against them. So really, by overruling Roe and Casey, the court won't have to go down that road, and a lot of those decisions are quite readily groundable in history, tradition, and the court's traditional factors, Your Honor.
Again, not the most intellectually satisfying a conclusion in my opinion, but it's a good lawyer's answer. It just isn't quite that satisfactory. I mean, it's a great answer. I can't think of a better answer. It's just like, maybe it's a legal purist thing. I don't know. But whatever it is, this answer is just not quite working for me, because he's not arguing that the decisions are correct from first principles, right? That's, I think, why the problem is. It's like he's not arguing that the decisions are correct from first principles, which would be more intellectually pure to me. He's arguing that the decisions, whatever problems they have from first principles, they have not proven to be unworkable. They've not proven to be unsustainable. They've not had these problems. So, like, it might have been wrong. It might have been the wrong answer, but, it's worked out. So let's just ignore it. It's not a bad answer, because the alternative answer is too much. It's way too much. I mean, you're already going to the U.S. Supreme Court and asking them to overturn Roe versus Wade, which is a huge ask. It's a huge ask. I mean, come on. You're asking them to overturn Roe and Casey. That's a pretty big ask. So, you don't need to make your life any more complex by saying, by the way, we want to also go through the whole panoply of cases and overturn those too, because our logic, the purity of our logic, would require that result. So he's like, well, that hasn't been a problem, so we can ignore it. It's a pragmatic answer. It's a realpolitik answer.
Thank you. Justice Thomas? Justice Breyer? Justice Alito? Justice Sotomayor? Kane? Justice?
General, I just wanted to get your quick sense of how your intermediate positions would work. If basically the viability line was discarded and undue burden became the standard overall, a standard that, according to you, is an unclear one, what that would leave the court with going forward. I'm just sort of thinking about the great variety of regulations that states could pass. So whether one is 15 weeks and one is 12 weeks and one is 9 weeks, or variation across a wide variety of other dimensions, what would that look like coming to the court? How do you think we would be able to deal with that, or how would you counsel us to deal with that if the court were to go down that road?
Well, I think this is not to push back against the end, and I will answer your question, Justice Kagan, but part of why we've counseled to overrule full scale is that that's the only way to get rid of a number of the problems that I think Your Honor is alluding to. And that's that when you have the undue burden standard, it's a very hard standard to apply. It's not objective. The court looks to the record in each case and what's going on. I mean, the court in Casey itself said under this record, this is not an undue burden. You couldn't say necessarily for certain that a certain number of weeks one place would be an undue burden, but would be okay another place. But again, that is the world we have under Casey. So if the court upholds this law under the undue burden standard, it would be carrying forward those features, which and I hope I've answered your question, but I think that's one of the very strong reasons to just go all the way and overrule Roe and Casey, Your Honor.
Not hiding the ball, man.
Anyway.
Justice Gorsuch? Justice Kavanaugh?
I want to be clear about what you're arguing and not arguing.
Yes.
And to be clear, you're not arguing that the court somehow has the authority to itself prohibit abortion, or that this court has the authority to order the states to prohibit abortion, as I understand it, correct?
Correct, Your Honor.
As I understand it, you're arguing that the Constitution's silent and therefore neutral on the question of abortion. In other words, that the Constitution's neither pro-life nor pro-choice on the question of abortion, but leaves the issue for the people of the states or perhaps Congress to resolve in the democratic process. Is that accurate?
Right. We're saying it's left to the people, Your Honor.
And so for if you were to prevail, the states, majority of states, or states still could and presumably would continue to freely allow abortion. Many states, some states, would be able to do that even if you prevail under your view. Is that correct? That's
consistent with our view, Your Honor. It's one that allows all interests to have full voice, and many of the abortions we see in certain states that I don't think anybody would think would be moving to change their laws in a more restrictive direction.
Thank you.
Thank you, Your Honor.
Justice Barrett?
General, I have a question that is a little bit of a follow-up to one that Justice Breyer was asking you. That's about stare decisis, and I think a lot of the colloquy you've had with all of us has been about the benefits of stare decisis, which I don't think anyone disputes. And, of course, no one can dispute because it's part of our...
Just by way of note, I mean, he's at 42 minutes in this. So he's way over his time. You get a half hour, and the justices just want to keep talking. So I guess as long as they keep talking, you just keep answering. So it's like, well, we're 12 minutes over time. Let's keep going, I guess.
Stare decisis doctrine, that it's not an inexorable command, and that there are some circumstances in which overruling is possible. You know, we have Plessy, Brown, we have Bowers versus Hardwick to Lawrence. But in thinking about stare decisis, which is obviously the core of this case, how should we be thinking about it? I mean, Justice Breyer pointed out that in Casey, and in some respects, well, it was a different conception of stare decisis insofar as it very explicitly took into account public reaction. Is that a factor that you accept? Or are you arguing that we should minimize that factor? And is there a different set of rules? It is true that Casey identified Brown and West Coast Hotel as watershed decisions, but is there a distinct set of stare decisis considerations applicable to what the court might decide as a watershed decision?
I don't think there should be a distinct set of considerations there, Your Honor. I think what I emphasize, and just to make sure, on the kind of legitimacy, the court looking outward, I think Casey was unusual in that regard. I think it was a mistake, and I think it's something that is kind of in conflict with this court's structure and approach as an independent branch, looking to the Constitution rather than looking without. And I think that's one reason why traditionally the court is in some of its greatest overrulings, it's not looking without. It's saying this was wrong. It was wrong the day it was decided. We know it's wrong today, and it's led to all these terrible consequences. We should get rid of it. So I think that was an unfortunate break, and I think the court, even if the court were to still look at legitimacy, though, Justice Barrett, I think the court could very, very powerfully say, look, our legitimacy really derives from our willingness to stand strong and stand firm in the face of whatever is going on, and stand for constitutional principle and follow our traditional stare decisis factors to overrule when it's appropriate. Thank you, Your Honor.
Thank you, counsel.
Thank you, Mr. Chief Justice.
I mean, you know, it's a fine argument. It's a fine argument. He doesn't hide the ball. He no magic tricks performed today. You know, just doing everything out in the open, so everyone can see exactly what's going on. So admirable. He's not hemming. He's not hawing. He's not couching. He's just being bold. It's like, yep, this is what I'm asking for. You all heard correctly the first time. I'm asking for you to overturn Roe. I'm asking for you to overturn Casey. No, it's not your ears. That's definitely a thing that I'm doing right now. And here's some reasons why you should do it. And, you know, here's why from stare decisis principles that's okay. And here's why it won't lead to a panoply of chaos in other cases and so forth and so on. And that the states can be trusted. And this is a question for the people, like hard questions, and et cetera, and so forth. So, you know, it's a calm, lucid, cogent, honest argument. It's very honest. And I like that very much. You know, I like that very much. You know, nothing to hide. Let's just, you know, this is what we're doing. No one's confused. We're not arguing anything else. This is exactly what we're trying to do. I appreciate that.
Ms. Rickleman?
Mr. Chief Justice, and may it please the Court, Mississippi's ban on abortion 2 months before viability is flatly unconstitutional under decades of precedent. Mississippi asks the Court to dismantle this precedent and allow states to force women to remain pregnant and give birth against their will. The Court should refuse to do so for at least 3 reasons. First, stare decisis presents an especially high bar here. In Casey, this Court carefully examined and rejected every possible reason for overruling Roe, holding that a woman's right to end a pregnancy before viability was a rule of law and a component of liberty it could not renounce. The question then is not whether Roe should be overturned, but whether Casey was egregiously wrong to adhere to Roe's central holding. Second, Casey and Roe were correct. For a state to take control of a woman's body and demand that she go through pregnancy and childbirth with all the physical risks and life-altering consequences that brings is a fundamental deprivation of her liberty. Preserving a woman's right to make this decision until viability protects her liberty while logically balancing the other interests at stake. Third, eliminating or reducing the right to abortion will propel women backwards. 2 generations have now relied on this right, and 1 out of every 4 women makes the decision to end a pregnancy. Mississippi's ban would particularly hurt women with a major health or life change during the course of a pregnancy, poor women who are twice as likely to be delayed in accessing care, and young people or those on contraception who take longer to recognize a pregnancy. To avoid profound damage to women's liberty, equality, and the rule of law, the court should affirm.
Counsel, I just have one question. I assume you, from your brief, you're relying on an autonomy theory.
Both bodily integrity and the ability to make decisions related to family, marriage, and childbearing, Your Honor.
Shortly, some years after we decided Casey, we had a case out of South Carolina, I believe, involved a woman who had been convicted of criminal child neglect because she ingested cocaine during pregnancy. In her case was post-viability, so it doesn't fit in the facts of this case. If she had ingested cocaine pre-viability and had the same negative consequences to her child, do you think the state had an interest in enforcing that law against her?
The state may have, Your Honor. The state can certainly regulate to serve its interests in fetal life and in women's health. Those particular laws tend to undermine both of those interests because they deter women from seeking prenatal care, which is counterproductive to both their health.
But the pre-viability as well as post-viability?
No, Your Honor. The court has been clear that after viability, states can prohibit abortion except to save
No,
women's
I mean in my example of criminal child neglect. I understand your argument is about abortion. I am trying to look at the issue of bodily autonomy and whether or not she has a right also to bodily autonomy in the case of ingesting an illegal substance and causing harm to a pre-viability fetus.
Your Honor, of course, those issues aren't posed in this case. And again, I would say that the states can certainly regulate throughout pregnancy, both before and after viability, to preserve fetal life and to preserve the woman's health.
Well, to preserve the woman's health, I guess, but to preserve fetal life doesn't quite make sense, does it? Because the state can regulate taking cocaine for the purpose of preserving fetal life that abortion itself can eliminate based on choice. It doesn't quite nicely sit together in the same universe, does it?
The court has said, however, there are other constitutional issues at stake. For instance, in the Ferguson case, that states still can't violate women's Fourth Amendment rights. But again, that's not what this case is about. This case is about a ban on abortion that the state concedes is weeks before viability. And the court has been clear for 50 years that the one thing that states cannot do is to take the decision completely away from the woman until viability. That until that point, it is her decision to make, given the unique physical demands of pregnancy and the life-altering consequences consequences of pregnancy and having a child.
Thank you.
The point you made about the impact on women and their place in society, those were certainly made in Roe as well. What we have before us, though, is a 15-week standard. Are you suggesting that the difference between 15 weeks and viability are going to have the same sort of impacts as you were talking about, or as we were talking about in Roe?
Yes, Your Honor, I believe they would, because people who need abortion after 15 weeks are often in the most challenging circumstances. As I mentioned, they're people who have perhaps had a major health or life change, a family illness, a job loss, a separation, young people or people who are on contraception or pregnant for the first time and who are delayed in recognizing the signs of pregnancy, or poor women who often have much more trouble navigating access to care. And if they're denied the ability to make this decision because there's a ban after 15 weeks, they will suffer all of the consequences that the court has talked about in the past. And in fact, the data has been very clear over the last 50 years that abortion has been critical to women's equal participation in society. It's been critical to their health, to their lives, their ability to pursue.
I'm sorry, what kind of data is that?
I would refer the court to the brief of The Economist in this case, Your Honor, and it compiles data showing studies based actually on causal inference, showing that it's the legalization of abortion and not other changes that have had these benefits for women in society. And again, those benefits are clear for education, for the ability to pursue a profession, for the ability to have.
Now, there's an interesting thing here about this. About these statistics, and I'm not commenting about what these briefs today say, but I'll take note. I'm pretty sure it might have been Roe. No, it couldn't have been Roe. It must have been Casey versus Planned Parenthood, I guess. But there was a line. The Supreme Court cited one study in its opinion from an economist or the equivalent, and they cited it for the proposition that more abortions causally led to increased opportunities for women. And actually, the Supreme Court just misread the study. Because when you go back and read the original study, it says the causal relationship is the other way around. More opportunities led to more abortions. So, yeah, they got the causal link around, the wrong way around. So I don't know what these studies today say in terms of the causality, but it's just an interesting little note there from a historical perspective.
Putting that data aside, if you think that the issue is one of choice, that women should have a choice to terminate their pregnancy, that supposes that there is a point at which they've had the fair choice, opportunity to choice. And why would 15 weeks be an inappropriate line? So viability, it seems to me, doesn't have anything to do with choice. But if it really is an issue about choice, why is 15 weeks not enough time?
For a few reasons, Your Honor. First, the state has conceded that some women will not be able to obtain an abortion before 15 weeks, and this law will bar them from doing so. And a reasonable possibility standard would be completely unworkable for the courts. It would be both less principled and less workable than viability, and some of the reasons for that are without viability, there will be no stopping point. States will rush to ban abortion at virtually any point in pregnancy. Mississippi itself has a 6-week ban that it's defending with very similar arguments as it's using to defend the 15-week ban, and there are states that have bans.
Well, I know, but I'd like to focus on the 15-week ban because that's not a dramatic departure from viability. It is the standard that the vast majority of other countries have. When you get to the viability standard, we share that standard with the People's Republic of China and North Korea. And I don't think you have to be in favor of looking to international law to set our constitutional standards to be concerned if those are your share that particular time period.
Yeah, this is an interesting aspect, right? So the United States is one of the most liberal, I suppose, free countries when it comes to abortion in the world, right? We're one of the most free countries in the world. There are some states where you can literally have an abortion up to the moment of birth. I believe New York's law is that way, if memory serves correctly. But yeah, and if Ralph Northam had his way, former governor of Virginia, even after birth, we keep the child comfortable while we decided what would happen. So that was a thing Ralph Northam said once. In any case, the vast majority of the world has much more conservative standards. So it's like, well, our law can be anything we want because, our law. But to the extent you care about international norms as informative, and you care about, for example, if the argument is that women need this up to the point of viability, because without that, some women won't be able to get the care, some women won't have abortions, some women won't know they're pregnant, some women won't, whatever, right? Some won't get to the care, and so this would be a disaster for women. To the extent that would be true in the United States, one would think logically that would have to be true in all the other countries of the world, right? All the other countries in the world would be having this problem. Do they have this problem? Are all the other countries in the world, are they markedly different when it comes to women in terms of their ability to progress and be part of society and stuff when it comes to, and even if they are, is it because of this issue? So, it's not really, it's undermining the factual assertion rather than the legal assertions. Like, pretty much China and North Korea are the ones who have our standard, and pretty much everyone else doesn't. So, it seems to have worked out for everyone else, without disaster area. So probably would work out for us too. So, what's her response to that? Should be interesting.
I think there's two questions there, Your Honor, if I may. First, that is not correct about international law. In fact, the majority of countries that permit legal access to abortion allow access right up until viability, even if they have nominal lines earlier. So, for example, Canada, Great Britain, and most of Europe allows access to abortion right up until viability, and it also doesn't have the same barriers in place.
What do you mean, even if they have nominal lines earlier?
Some countries, Your Honor, have a nominal line of 12 weeks or 18 weeks, but they permit legal access to abortion after that point for broad social reasons, health reasons, socioeconomic reasons. So their regimes really aren't comparable, and they also don't have the same types of barriers that we have here. So if the court were to move the line substantially backwards, and 15 weeks is 9 weeks before viability, Your Honor, it's quite a bit backwards, it may need to reconsider the rules around regulations, because if it's cutting the time period to obtain an abortion roughly in half, then those barriers are going to be much more important.
Thank you.
Ms. Rickelman, I have a question about the safe haven laws. So petitioner points out that in all 50 states, you can terminate parental rights by relinquishing a child after abortion, and I think the shortest period might have been 48 hours, if I'm remembering the data correctly. So it seems to me, seen in that light, both Roe and Casey emphasized the burdens of parenting. And insofar as you and many of your amici focus on the ways in which the forced parenting, forced motherhood would hinder women's access to the workplace and to equal opportunities. It's also focused on the consequences of parenting and the obligations of motherhood that flow from pregnancy. Why don't the safe haven laws take care of that problem? It seems to me that it focuses the burden much more narrowly. There is, without question, an infringement on bodily autonomy, which we have in other contexts like vaccines. However, it doesn't seem to me to
Nice little poke there from Manny Coney Barrett. It's like, this infringes bodily autonomy like vaccines do. Just a little poke the bear there. I like that one personally.
Follow that pregnancy and then parenthood are all part of the same burden. And so it seems to me that the choice more focused would be between, say, the ability to get an abortion at 23 weeks or the state requiring the woman to go 15, 16 weeks more and then terminate parental rights at the conclusion. Why didn't you address the safe haven laws, and why don't they matter?
I think they don't matter for a couple of reasons, Your Honor. First, even if some of those laws are new since Casey, the idea that a woman could place a child up for adoption has, of course, been true since Roe, so it's a consideration that the court already had before it when it decided those cases and adhered to the viability line. But in addition, we don't just focus on the burdens of parenting, and neither did Roe and Casey. Instead, pregnancy itself is unique. It imposes unique physical demands and risk on women, and in fact has impact on all of their lives, on their ability to care for other children, other family members, on their ability to work. And in particular, in Mississippi, those risks are alarmingly high. It's 75 times more dangerous to give birth in Mississippi than it is to have a pre-viability abortion, and those risks are disproportionately threatening the lives of women of color.
First of all, 75 times different. Damn. Because what was it like? I forget what the other number was in general, but it was like 14 times or something. So Mississippi apparently is, what is that, like 6 times worse than the national average on this issue? So first of all, holy shit, dude. It sounds to me like if your rate is 6 times, if it's really that high, sounds to me like you might want to do something in terms of health policy to, you know, get that down to something more approaching the reasonable national average. Second of all, the fact that we're disproportionately threatening the lives of women of color. Man, come on. Jesus Lord.
So are you saying, I mean, actually, as I read Roe and Casey, they don't talk very much about adoption. It's a passing reference that means out of the obligations of parenthood. But as I hear this answer, then are you saying that the right, as you conceive of it, is grounded primarily in the bearing of the child and the carrying of pregnancy, and not so much looking forward into the consequences on professional opportunities and work life and economic burdens?
No, Your Honor. I believe it's both, and that is exactly how Casey talked about it. It talked about the 2 strands of cases that supported the right. One was the strand of cases supporting bodily integrity, and it cited to cases like Cruzan and Riggins versus Nevada. And the second was the strand of cases supporting decisional autonomy, and specifically decisions related to childbearing, marriage, and procreation decisions like Griswold, Loving. And so it's really both strands that we're relying on here.
May I ask you a question about stare decisis, counsel? Your colleagues on the other side have emphasized that Casey rejected Roe's trimester framework and replaced it with an undue burden standard. They argue that the undue burden standard was not well known to the law before that. And then they argue that the undue burden standard has evolved over time, too, in ways that the court has found difficult to agree upon. In Hellerstedt, for example, they point out in their briefs that the court seemed to suggest that a court should consider both the benefits and the burdens associated with the proposed restriction. In June Medical, more recently, the court splintered on that same question, whether benefits could be considered or only burdens. And so the argument goes that this has proved to be putting aside all the other obviously difficult questions in the case, that the standard itself has proved difficult to administer, and that is relevant to the stare decisis analysis. And I just wanted to give you an opportunity to respond.
Yes, Your Honor. The first point I'd like to make is the undue burden test is not at issue in this case. That is the test that applies to regulations, not prohibitions, and the state has conceded that this is a prohibition. In fact, that's the title of this law, is an act to prohibit abortion after 15 weeks. And the only thing that's at issue in this case is the viability line, and the viability line has been enduringly workable. The lower federal courts have applied it consistently and uniformly for 50 years, and the Fifth Circuit here below had no difficulty striking down this law.
I'm not 100% on that one. The problem with the viability line is determining when viability is, or how do you measure that exactly. And states have tried various things to, like, put various tests into law. They've tried, like, week numbers, they've tried, like, test numbers, and those haven't been particularly successful either. So it's like, yeah, you can ban it after viability, but how exactly you determine that, and what does that exactly mean? To be viable. Do you mean like half the time, or do you mean 1% of the time, or do you mean at all? I believe if memory serves correctly, the current record for a premature birth that was successful is something like 22 weeks, or maybe it's 21 weeks. So are we going to like the least common denominator here? So yeah, I'm not 100% sure about that viability thing being a standard that's really been super duper easy for everyone to apply, and also even worse is the undue burden standard, which no one has any clue what that means, but yeah, still.
Unanimously 3-0. So it's been an exceedingly workable standard. And if I may return to your question, Mr. Chief Justice, a reasonable possibility standard would not be workable. It would ultimately boil down to an argument that states can prohibit a category of women from exercising a constitutional right merely because of the number of people in the category. And that's just not how constitutional rights work. A state would never say that it could ban religious services on a Wednesday evening, for example, simply because most people could attend religious services on another night of the week.
So I actually just wanted to, that's helpful, I think. I just want to make sure I understand what you're telling me, counsel, that if the court were to, in this case, step past viability and apply undue burden, the undue burden test to regulations prior to viability, you would agree with the other side, I think, that that's not a workable standard. Is that a fair understanding what you're telling the court?
No, Your Honor. I
believe, think that would be workable?
I believe that, if I may clarify, I believe the undue burden test has been workable for regulations. That
I understand that. If it were to apply, if the court were to, and I thought this is what you were saying in response to the Chief Justice, but maybe I'm mistaken. Please correct me if I am. But what is your argument against applying the undue burden standard prior to viability?
If the undue burden standard, as this court laid out in Casey, which includes the viability line,
No, I'm asking. I know, we're fighting the hypothetical here, counsel. All right, accept the hypothetical. Hypothetically, the court were to extend the undue burden standard to regulations prior to viability. Would that be workable, or would that not be workable in your view?
Without viability, it would not be workable, Your Honor, because it would ultimately, again, always come down to a claim that states can bar a certain category of people from exercising this right simply because of the number of people in the category. And that's not a workable standard, and it's not a constitutional.
I appreciate that clarification. Thank you.
Just to follow up on that, I read your brief to say that the only real options we have are to reaffirm Roe and Casey as they stand, or to overrule them in their entirety. You say that, quote, there are no half measures here. Is that a correct
insert speech from Mike Ehrmantraut talking about half measures at this point. In fact, hold on. Just because I can, because my stream. Hold on.
Well, you got a good thing going here. We all do. You want to risk it all on one junkie? Now, I realize you two have a history, but this kid's been on the bubble a while now. It's a long time coming.
What is?
I used to be a beat cop a long time ago. And I'd get called out on domestic disputes all the time, hundreds probably over the years. But there was this one guy, this one piece of shit that I will never forget. Gordy. He looked like Bo Svensson. You remember him? Walking tall, you don't remember? No. Anyway. Big boy. 270, 280. But his wife, or whatever she was, lady, was real small. Like a bird. Wrists like little branches. Anyway, my partner and I get called out there every weekend. And one of us would pull her aside and we'd say, come on, tonight's the night we press charges. And this wasn't one of those deep down, he really loves me setups. We got a lot of those, but not this. This girl was scared. She wasn't going to cross him, no way, no how. Nothing we could do but pass her off to the EMTs, put him in a car, drive him downtown, throw him in a drunk tank. He sleeps it off. Next morning, out he goes. Back home. And one night, my partner's out sick, and it's just me. And the call comes in, and it's the usual crap. Broke her nose in the shower kind of thing. So I cuff him, put him in the car, and away we go. Only that night, we're driving into town, and this sideways asshole is in my back seat humming Danny Boy. And it just rubbed me wrong. So instead of left, I go right out into nowhere. And I kneel him down, and I put my revolver in his mouth. And I told him, this is it. This is how it ends. And he's crying, going to the bathroom all over himself, swearing to God he's gonna leave her alone, screaming as much as you can with a gun in your mouth. And I told him to be quiet. But I need to think about what I was gonna do here. And of course he got quiet. Goes still. And real quiet. Like a dog waiting for dinner scraps. And we just stood there for a while. Me acting like I'm thinking things over. And Prince Charming kneeling in the dirt with shit in his pants. And after a few minutes, I took the gun out of his mouth. And I say, so help me, if you ever touch her again, I will such and such and such and such and blah, 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 blah.
Just a warning.
Of course. Just trying to do the right thing. But 2 weeks later, he killed her. Of course. Caved her head in with the base of a Waring blender. We got there was so much blood you could taste the metal. The moral of the story is, I chose a half measure when I should have gone all the way. I'll never make that mistake again.
Understanding of your brief.
Your Honor, it's certainly the arguments that the state has presented is what we're responding to there, which is that all of the state's arguments, including their alternatives, which are undue burden without viability, would be the equivalent of overruling Casey and Roe, because the viability line is the central holding of those cases. Casey mentioned it no fewer than 19 times, and the court in June Medical just a year ago affirmed that the viability line is the central holding of both Casey and Roe.
Well, you do emphasize that the court drew the line at viability in Roe and reaffirmed that in Casey, and that is certainly something that we have to take very seriously into consideration. But suppose we were considering that question now for the first time. I'm sure you know the arguments about the viability line as well as I do, probably better than I do. What would you say in defense of that line? What would you say to the argument that has been made many times by people who are pro-choice and pro-life that the line really doesn't make any sense, that it is, as Justice Blackmun himself described it, arbitrary? If a woman wants to be free of the burdens of pregnancy, that interest does not disappear the moment the viability line is crossed. Isn't that right?
No, Your Honor. And if I may make a few points to answer your question. First, I think the state views viability as arbitrary because it completely discounts the woman's interest. But viability.
No, but does a woman have, upon reaching the point of viability, does not the woman have the same interest that she had before viability in being free of this pregnancy that she no longer wants to continue?
Viability is a principled line, Your Honor, because in ordering the
I'm trying to see whether it is a principled line.
Yeah,
you agree with me at least on that point, that a woman still has the same interest in terminating her pregnancy after the viability line has been crossed?
Yes, Your Honor, but the court balanced the interest in ordering the interest
at stake. Look at the interest on the other side. The fetus has an interest in having a life, and that doesn't change, does it, from the point before viability to the point after viability?
In some people's view, it doesn't, Your Honor, but what the court said is that those philosophical differences couldn't be resolved in a way.
That's what I'm getting at. What is the philosophical argument, the secular philosophical argument for saying this is the appropriate line? There are those who say that the rights of personhood should be considered to have taken hold at a point when the fetus acquires certain independent characteristics. But viability is dependent on medical technology and medical practice. It has changed. It may continue to change.
No, Your Honor. It is principled because in ordering the interest at stake, the court had to set a line between conception and birth, and it logically looked at the fetus's ability to survive separately as a legal line because it's objectively verifiable and doesn't require the court to resolve the philosophical issues at stake.
It does require the court to resolve the philosophical issues at stake. You're resolving it philosophically at viability. That's a resolution of the philosophical issues. So it did require the court to resolve the issues of philosophical. They chose viability, which, has philosophical arguments like pretty much any other position for various reasons, but it's a philosophical line too.
I just want to focus on stare decisis for a little bit. I found my colleague, Justice Breyer's comments quite compelling. I'm not quite sure how they play out in Casey. It is certainly true that we cannot base our decisions on whether they're popular or not with the people. Casey seemed to say we shouldn't base our decisions not only on that, but whether they're going to seem popular. And it seemed to me to have a paradoxical conclusion that the more unpopular the decisions are, the firmer the court should be in not departing from prior precedent. It's sort of a super stare decisis. But it's super stare decisis for what are regarded as, by many, as the most erroneous decisions. Do you think there is that category, or is it just normal stare decisis?
Super precedent. Super precedent. That's what Dianne Feinstein would say, and that's the question that just Robert just said. Hey, is there such a thing as super precedent? I love it, man. That's great shit.
I think it is precedent on precedent, Your Honor, because Casey did the stare decisis analysis for Roe. So the question before this court is whether that stare decisis analysis was egregiously wrong. And if I may answer your earlier question about whether viability was squarely at issue in Casey, it clearly was, Your Honor. At pages 869 to 871, the court squarely addressed viability because the government had made the argument that viability was arbitrary.
I appreciate that Casey addressed it, but that's different than saying it was at issue. It said it was the central principle of Roe because it was pretty much all that was left after they were done dealing with the rest of it. And the regulations in Casey had no applicability or not depending upon where viability was. They applied throughout the whole range, period. So if they didn't say anything about viability, it's like what Justice Blackmun said when discussing among his colleagues, which is a good reason not to have papers out that early, is that they don't have to address the line drawing at all in Roe, and they didn't have to address the line drawing at all in Casey.
I disagree with that, Your Honor, because the undue burden test incorporates the viability line. That was what the court was assessing the regulations against, whether they imposed a substantial obstacle in the path of a woman before viability. And if a prohibition like this law isn't a substantial obstacle, then nothing would be. So the issue was squarely before the court, and in fact the court said at page 879 that in adopting the undue burden test it was not disturbing the viability line.
It's a very interesting question that I think Justice Barrett raised too. it's usually just philosophical, but I think it has bite here. When I read Casey, it's not just one-on-one. 2 is greater than 1. Yeah, Casey plus Roe is greater than. They're making a point that we're an institution perhaps more than a court of appeals or a district court. It's Hamilton's point. No purse, no sword.
What?
And yet we have to have public support. And that comes primarily, says Casey. I wonder if it was O'Connor who wrote that. I don't know. But it comes primarily from people believing that we do our job.
What the hell is Breyer talking about? What the hell? No purse, no sword. What are we? What?
We use reason. We don't look to just what's popular. And that's where you're seeing the paradox. But the problem with the super case, of which we've heard 3 mentioned, the problem with the super case like this, the rare case, the watershed case, where people are really opposed on both sides, and they really fight each other, is they're going to be ready to say, no, you're just political, you're just politicians. And that's what kills us as an American institution. That's what they're saying. So we're looking at it for that, but we are looking to, and that, they say, is a reason why. A reason why. When you get a case like that, you better be damn sure that the normal stare considerations, stare decisis overruling are really there in spades, double, triple, quadruple, and then they go through and show they're not. Okay? What's the paradox? Maybe you think I've just made an argument that there isn't one, but really, in my head, I'm thinking I'm not sure. There may be one, and I don't know if you've ever thought about this. I don't know if you've ever, when that occurred to you. I don't want to overrule the stare. I wouldn't want the court to overrule the stare decisis section of Casey. You say, and that's what I think is being brought up, and maybe I haven't made it clearer, but I've tried to.
I mean, this is no surprise to anyone who watches the channel, but I find Justice Breyer's questionings by far the hardest to follow. This is no exception. I found it to be a rambling, confusing mess. Some people in the chat apparently thought that it made sense to them, and all I have to say to you is Godspeed, man. If that made sense to you, then, fine. But, there are definitely people more left on the court. Sotomayor is definitely more left than Breyer. And whatever problems I have about Sotomayor, which are many, Sotomayor is not incoherent. And, man, Breyer stayed too long at the fair, man. That's what I think.
Yes, Your Honor. I think the point that the court was making was that the fact that some states may continue to enact laws in the teeth of the court's precedent has never been enough of a reason to overrule. And that's true for a number of decisions that the court has issued. The fact that some people continue to disagree with them is not a basis to discard that precedent.
Justice Thomas, anything further?
Back to my original question. I know your interest here is in abortion. I understand that. But if I were to ask you what constitutional right protects the right to abortion, is it privacy? Is it autonomy? What would it be?
It's liberty, Your Honor. It's the textual protection in the 14th Amendment that a state can't deprive a person of liberty without due process of law. And the court has interpreted liberty to include the right to make family decisions and the right to physical autonomy, including the right to end a pre-viability pregnancy.
So it's all of the above.
Well, that's how the court has interpreted the Liberty Clause for over 100 years in cases going back to Meyer, Griswold, Carey, Loving, Lawrence.
Yeah, but I mean, all of those sort of just come out of Lochner. So it's we've dropped part of it. So I understand what you're saying, but what I'm trying to focus on is to lower the level of generality, or at least be a little bit more specific. In the old days, we used to say it was a right to privacy that the court found in the substantive due process clause, okay? So, or in substantive due process. And I'm trying to get you to tell me, what are we relying on now? Is it privacy? Is it autonomy? What is it?
I think it continues to be liberty, and the right exists whatever level of generality the court applies. There was a tradition under the common law for centuries of women being able to end their pregnancies. But in addition, when it comes to decisions related to family, marriage, and childbearing, the court has done the analysis at a higher level of generality, and that makes sense because otherwise the Constitution would reinforce the historical discrimination against women.
Thank you. Justice Breyer? Justice Alito?
Well, you just mentioned the common law, so let me ask you a couple of questions about history. Did any state constitutional provision recognize that abortion was a right, liberty, or immunity in 1868 when the 14th Amendment was adopted?
No, Your Honor, but it had been allowed under the common law for many years.
Does any judicial decision at that time, or shortly or immediately after 1868, recognize that abortion was a right, liberty, or immunity?
There were state high court decisions shortly before then, Your Honor, talking about the ability of women to end a pregnancy before quickening.
What's your best case?
For the right to end a pregnancy, Your Honor?
Mm-hmm.
Allowing a state to take control of a woman's body and force her to undergo the physical demands, risks, and life-altering consequences of pregnancy is a fundamental deprivation of her liberty. And once the court recognizes that that liberty interest deserves heightened protection, it does need to draw a workable line, and viability is a line that logically balances the interests at stake.
The brief for the American Historical Association says that abortion was not legal before quickening in 26 out of 37 states at the time when the 14th Amendment was adopted. Is that correct?
That is correct, because some of the states had started to discard the common law at that point because of a discriminatory view that a woman's proper role was as a wife and mother, a view that the Constitution now rejects, and that's why it's appropriate to do the historical analysis at a higher level of generality.
In the face of that, can it be said that the right to abortion is deeply rooted in the history and traditions of the American people?
Yes, it can, Your Honor. Again, at the founding, women were able to end their pregnancy under the common law. And in fact, this court in Glucksburg specifically discussed Casey as a decision based on history and tradition. And at note 19 specifically called out and relied on Roe's conclusion that at the time of the founding and well into the 1800s, women had the ability to end a pregnancy.
I mean, I'll give her credit, man. I think she's a very good advocate. I haven't really commented on this yet to date. But I think she's a very good advocate. She's extremely well informed. She knows the history. She knows the cases. She knows the briefs, man. She's good. I like her. I think she's a very good advocate. She's a very good person for her side. She knows what her client wants. She knows the material cold to be able to do it. She's really on the ball. She's got it down. And she's even trying to make historical arguments and tradition arguments to try to kind of rebut some of the stuff that's been argued before. So, credit where credit's due, man. I think she's very good. I think she's at least on par with the Solicitor General who started this thing. So, points.
What was the principal source that the court relied on in Roe for its historical analysis? Who was the author of that article?
I apologize, Your Honor. I don't remember the author. I know that the court spent many pages of the opinion doing a historical analysis. There's also a brief on behalf of several key American historian associations that go through that history in detail, because there's even more information now that supports Roe's legal conclusions.
All right, thank you.
think the other side would say that the core problem here is that the court has been forced by the position you're taking and by the cases to pick sides on the most contentious social debate in American life, and to do so in a situation where they say that the Constitution is neutral on the question of abortion, the text and history, that the Constitution's neither pro-life nor pro-choice on the question of abortion, and they would say, therefore, it should be left to the people, to the states, or to Congress. And I think they also then continue, because the Constitution is neutral, that this court should be scrupulously neutral on the question of abortion, neither pro-choice nor pro-life. But because they say the Constitution doesn't give us the authority, we should leave it to the states, and we should be scrupulously neutral on the question. And that they are saying here, I think, that we should return to a position of neutrality on that contentious social issue rather than continuing to pick sides on that issue. So I think that's, at a big picture level, their argument. I want to give you a chance to respond to that.
Yes, a few points, if I may, Your Honor. First, of course, those very same arguments were made in Casey, and the court rejected them, saying that this philosophical disagreements can't be resolved in a way that a woman has no choice in the matter. And second, I don't think it would be a neutral position. The Constitution provides a guarantee of liberty. The court has interpreted that liberty to include the ability to make decisions related to childbearing, marriage, and family. Women have an equal right to liberty under the Constitution, Your Honor, and if they're not able to make this decision, if states can take control of women's bodies and force them to endure months of pregnancy and childbirth, then they will never have equal status under the Constitution.
And I want to ask a question about stare decisis and to think about how to approach that here, because there have been lots of questions picking up on Justice Barrett's questions and others. And history helps. Think about stare decisis as I've looked at it, and the history of how the courts applied stare decisis. And when you really dig into it, history tells a somewhat different story, I think, than is sometimes assumed. If you think about some of the most important cases, the most consequential cases in this court's history, there's a string of them where the cases overruled precedent. Brown v. Board, outlawed separate but equal. Baker versus Carr, which set the stage for one person, one vote. West Coast Hotel, which recognized the state's authority to regulate business. Miranda versus Arizona, which required police to give warnings when about the right to remain silent and to have an attorney present to suspects in criminal custody. Lawrence v. Texas, which said that the state may not prohibit same-sex conduct. Knapp versus Ohio, which held that the exclusionary rule applies to state criminal prosecutions to exclude evidence obtained in violation of the Fourth Amendment. Gideon versus Wainwright, which guaranteed the right to counsel in criminal cases. Obergefell, which recognized a constitutional right to same-sex marriage. In each of those cases, and that's a list, and I could go on, and those are some of the most consequential and important in the court's history, the court overruled precedent. And it turns out if the court in those cases had listened, and they were presented with arguments in those cases, adhere to precedent. In Brown v. Board, adhere to Plessy. In West Coast Hotel, adhere to Atkins and adhere to Lochner. And if the court had done that in those cases, the country would be a much different place. So I assume you agree with most, if not all, the cases I listed there where the court overruled precedent. So the question on stare decisis is why, if, and I know you disagree with what I'm about to say in the if we think that the prior precedents are seriously wrong, if that, why then doesn't the history of this court's practice with respect to those cases tell us that the right answer is actually to return to the position of neutrality and not stick with those precedents in the same way that all those other cases didn't?
Because the view that a previous precedent is wrong, Your Honor, has never been enough for this Court to overrule, and it certainly shouldn't be enough here when there's 50 years of precedent. Instead, the Court has required something else, a special justification, and the State doesn't come forward with any special justification. It makes the same exact arguments the Court already considered and rejected in its stare decisis analysis in Casey, and in fact, there is nothing different. There is no less need today than 30 years ago or 50 years ago for women to be able to make this fundamental decision for themselves about their bodies, lives, and health.
Not a bad answer. Not a bad answer. Not, again, kind of not intellectually pure for the same reason that the guy's answer to this question is kind of not intellectually pure. You know, it's kind of like a precedential argument. It's not going from first principles, so has the same intellectual purity problems for me. It's like, you know, to limit his principles, he's saying, well, you know, this case is completely whacked out, but those other cases aren't whacked out, so let's preserve them, right? It's a pragmatic argument. And she's like, well, okay, we disagree the case is whacked out. You know, we disagree it's whacked out. We think it's been fine, and so therefore preserve it, right? But neither argument's going from first principles. So it's a little bit intellectually not satisfying for me, but, you know, it's a perfectly fine argument, you know. So, I mean, yeah, leaves a little bit to be desired.
Thank you.
Justice Barrett?
I want to ask you a follow-up question. You know, the Chief was asking about the viability line and if that was the right place, if that's the right line to draw. So let's take it out of the question of stare decisis and imagine that there's a state constitution that's identical to the 14th Amendment's due process clause. And a state Supreme Court has to decide as a matter of state constitutional law what the scope of an abortion right is. And the second trimester ends at 27 weeks. And so that state Supreme Court says, we think that the right exists, you know, in an absolute sense that the state cannot take away the right up to 27 weeks, and then after that adopts an undue burden standard. As a matter of first principles, is that line acceptable as a matter of constitutional law?
Your Honor, it may be, but I think that the question in this case is whether a line is obviously more principled or obviously more workable than viability.
She didn't fall into the trap.
Why? I mean,
she didn't fall into the trap. I think that question was a trap question. I think it was a trap question. So she says, okay, let's imagine some state is considering its state law. We'll take note that the second trimester ends at 27 weeks, which is well past viability. And so this particular state court, whoever they are, the state Supreme Court says that abortion before 27 weeks is perfectly fine, no limits, and then after that, undue burden. Is that okay? And 27 is obviously a lot. Is viability. You know, it's viability. And so I think it's a trap question because I think if she answers yes, you know, I think that the next questions is probably going to roll it back down. It's like, well, if 27 weeks, why not this week? And there are answers to that. I mean, obviously, she can answer it because viability is in line and 27 weeks is beyond the viability determination. So, you know, but I think it was a trap question. I think she avoided the trap. So.
The Roe framework, basically the trimester, why wouldn't that be workable if you pick a line and say the end of the second trimester, 27 weeks, third trimester, states' interests increase? I don't understand why 27 weeks is less workable than 24.
I'm not trying to suggest it is, Your Honor. And what I was trying to suggest is that the viability line is a principled and workable line. So to change it, there would have to be a new line that's obviously more principled and more workable. And the line that the Court has drawn actually...
But that's stare decisis. I'm asking as a matter of first principles.
As a matter of first principle, the viability line makes sense because if the state constitution is the same...
As a matter of prudential judgment. It's not constitutionally required as a matter of first principles because, in fact, we could decide to be more protective and say 27 weeks end of the second trimester.
You could, Your Honor, but the viability line makes sense given the protection for liberty because it comes from the woman's liberty interest in resisting state control of her body. And once the Court recognizes that interest, it does need to draw a line.
Yeah, I think she's avoiding the trap. I think she's avoiding the trap. It's like, hey, this is even better than viability. Why not that, right? I think she's very, very smart. I think she's very, very smart. And I like this answer. I like this answer. I think that, hey, viability is 24 weeks. How about 27 weeks? All right, that's even better. And, and so she's like, well, you could do that, but we think viability is the right answer. So she's not accepting the bait. She's not accepting the bait, because the moment she detaches herself from viability, right, the moment she detaches herself from viability and she said 27 weeks, unless she has the ability to recount that or something, the moment she detaches herself, she loses. So I think she saw the trap, which proves that she's smarter than me, because I'm not sure I would have seen the trap in the moment. And or she's just more practiced. Maybe she's not smarter than me. Maybe she's just practiced harder, which is also a perfectly possible answer. She's had more practice sessions and stuff like that, so she kind of expected this, or maybe. But either way, I think she was very, very smart to avoid the trap of, well, this is even better, so why not, and stick to her original position and not move her position. I think that was a very, very smart for her. I like that answer very, very much. Good for her.
As it does in many other constitutional contexts, like the Fourth and Fifth Amendment. And the viability line, as I mentioned, makes sense because it focuses on the fetus's ability to survive separately, which is an appropriate legal line because it's objectively verifiable and doesn't delve into philosophical questions about when life begins.
Thank you, counsel.
This is going to be the U.S. government, by the way.
Mr. Chief Justice, and may it please the Court. For a half-century, this Court has correctly recognized that the Constitution protects a woman's fundamental right to decide whether to end a pregnancy before viability. That guarantee that the state cannot force a woman to carry a pregnancy to term and give birth has engendered substantial individual and societal reliance. The real-world effects of overruling Roe and Casey would be severe and swift. Nearly half of the states already have or are expected to enact bans on abortion at all stages of pregnancy, many without exceptions for rape or incest. Women who are unable to travel hundreds of miles to gain access to legal abortion will be required to continue with their pregnancies and give birth, with profound effects on their bodies, their health, and the course of their lives. If this Court renounces the liberty interest recognized in Roe and reaffirmed in Casey, it would be an unprecedented contraction of individual rights and a stark departure from principles of stare decisis. The Court has never revoked a right that is so fundamental to so many Americans and so central to their ability to participate fully and equally in society. The Court should not overrule this central component of women's liberty.
General, would you specifically tell me, state what the right is? Is it specifically abortion? Is it liberty? Is it autonomy? Is it privacy?
The right is grounded in the liberty component of the 14th Amendment, Justice Thomas, but I think that it promotes interests in autonomy, bodily integrity, liberty, and equality. And I do think that it is specifically the right to abortion here, the right of a woman to be able to control without the state forcing her to continue a pregnancy, whether to carry that baby to term.
I understand we're talking about abortion here, but what is confusing is that if we were talking about the Second Amendment, I know exactly what we're talking about. If we're talking about the Fourth Amendment, I know what we're talking about because it's written, it's there. What specifically is the right here that we're talking about?
Well, Justice Thomas, I think that the Court in those other contexts with respect to those other amendments has had to articulate what the text means and the bounds of the constitutional guarantees. And it's done so through a variety of different tests that implement First Amendment rights, Second Amendment rights, Fourth Amendment rights. So I don't think that there is anything unprecedented or anomalous about the right that the Court articulated in Roe and Casey and the way that it implemented that right by defining the scope of the liberty interest by reference to viability and providing that that is the moment when the balance of interest tips and when the state can act to prohibit a woman from getting an abortion based on its interest in protecting the fetal life at that point.
So the right specifically is abortion?
It's the right of a woman prior to viability to control whether to continue with a pregnancy, yes.
Thank you.
General, I am interested in Justice Kavanaugh's long litany of cases in which we've overruled precedent, and we have. Yet you did call this unprecedented. As I see the structure of the Constitution, the body of it is the relationship of the three branches of government, and then there is the relationship of the federal government to the state, and through our incorporation of the 14th Amendment of the state vis-a-vis the individual, it's the federal government and the state's relationship to individuals. And I see the Bill of Rights, including the 14th Amendment, as basically setting the limits, giving individual freedom to do certain things, and stopping the government from intruding in those liberties, in those Bill of Rights, correct? Of all of the decisions that Justice Kavanaugh listed, all of them virtually, except for maybe one, involved us recognizing and overturning state control over issues that we said belong to individuals. The right in Miranda to be warned was an individual right, correct?
That's right, Justice Sotomayor, and I think that that is a key distinction with the list of precedents that Justice Kavanaugh was relying on. I think that there are really two key distinctions, and the first is that in the vast majority of those cases, the court was actually taking the issue away from the people and saying that it had been wrong before not to recognize a right. And I think that matters because it goes straight to reliance interests. Here, the court would be doing the opposite. It would be telling the women of America that it was wrong, that actually the ability to control their bodies and perhaps the most important decision they can make about whether to bring a child into this world is not part of their protected liberty. And I think that that would come at tremendous cost to the reliance that women have placed on this right and on societal reliance and what this right has meant for further ensuring
reliance
equality.
Point is a good point, and this may be my fault. I'm talking about pages 854 to 863 in the Casey case, and I've already used up too much time. I can't read those pages out loud.
Thank God. Thank God Justice Breyer knows restraint. He's not going to read us. He's not going to read us 9 pages. He's not going to read us a 9-page thing as part of his question, man. There's light. There's hope. There's hope. Oof.
But they do not include the list that Justice Kavanaugh had. They do include 2. One is Brown, and the second one is West Coast Hotel versus Parrish. And you could add the gay rights cases as a third, which would fit the criteria. But there are complex criteria that she's talking about that link to the position in the rule of law of this court. So all I would say is you have to read them before beginning to say whether they are overruling or not overruling in the sense meant there, calling for special concern. Now, they say in those, maybe I'd mention 2. Wait a minute. Of course, Plessy was wrong when decided, but just a minute. Also remember, Plessy said that separate but equal was a badge of inferiority. No, they said it isn't. Well, all you have to do is open your eyes and look at the South, my friend, and you will see whether it was or it wasn't in 1954. And they made a similar point. They said, are you going to sit here in the middle of the Depression and tell me that Lochner, with its other cases, and pure, just about pure laissez-faire, that we can run the country that way? I mention that because I want people to read those 15 pages with care. And that's why I said that. If you had anything to add to my plea to read it,
please do.
Well, Justice Breyer, I agree completely. I have read those pages and reread them many times, and I think that this is actually another key distinction from the cases that Justice Kavanaugh was referring to, and that is, as I understand those passages in Casey, the Court carefully walked through each and every stare decisis factor that this Court focuses on. It looked at workability of the viability rule, doctrinal underpinnings, legal and factual developments, and critically reliance interests. And down the line, it found that the case for reaffirming Roe was overwhelming. And in that situation, when every factor that the Court consults to determine whether to retain precedent counsels in favor of retaining it, I think Casey properly perceived that a decision to overrule nevertheless, perhaps based on conclusion that the justices thought the case was wrongly decided in the first instance, would run counter to the ability of stare decisis to function as a cornerstone of the rule of law in this context.
Is it your argument that a case can never be overruled simply because it was egregiously wrong?
I think that at the very least, the state would have to come forward with some kind of materially changed circumstance or some kind of materially new argument, and Mississippi hasn't done so in this
really?
case.
So suppose Plessy versus Ferguson was re-argued in 1897, so nothing had changed. Would it not be sufficient to say that was an egregiously wrong decision on the day it was handed down, and now it should be overruled?
It certainly was egregiously wrong on the day that it was handed down, Plessy, but what the Court said in analyzing Plessy to Brown and Casey was that what had become clear is that the factual premise that underlay the decision, this idea that segregation didn't create a badge of inferiority, had been entirely mistaken.
So
and
is it your answer that we needed all the experience from 1896 to 1954 to realize that Plessy was wrongly decided? Would you answer my question? Had it come before the Court in 1897, should it have been overruled or not?
I think it should have.
And incidentally, there have been cases, well, I don't think the next year has ever happened, but there have been cases that the Supreme Court has overruled itself in relatively quick succession. I don't know if it's the record, but I think it might be the quickest turnaround. Certainly the quickest turnaround I know about. The quickest turnaround I know from the Supreme Court reversing itself was about 4 years, from saying that the Pledge of Allegiance was required for all students in schools and they all had to stand and say the Pledge of Allegiance, to saying the exact opposite of that thing. I'm not sure if that's the fastest. I think there might be faster, but that's an example where the Supreme Court can turn itself around. So,
have been overruled, but I think that the factual premise was wrong in the moment it was decided, and the Court realized that and clarified that when it overruled.
So there are circumstances in which a decision may be overruled, properly overruled, when it must be overruled, simply because it was egregiously wrong at the moment it was decided.
Well, I think every other stare decisis factor likewise would have justified overruling in that interest, that actually it would run counter to any notion of reasonable reliance, that it was not a workable rule, that it had become an outlier in our understanding of fundamental freedoms.
Well, there was a lot of reliance on Plessy. The South built up a whole society based on the idea of white supremacy. So there was a lot of reliance. It was improper reliance. It was reliance on an egregiously wrong understanding of what equal protection means. But your answer is, I still don't understand. I still don't have your answer clearly. Can a decision be overruled simply because it was erroneously wrong, even if nothing has changed between the time of that decision and the time when the Court is called upon to consider whether it should be overruled? Yes or no? Can you give me a yes or no answer on that?
This Court, no, has never overruled in that situation just based on a conclusion.
Again, this goes to either her being smarter than me, and this is, by the way, this is a different advocate. This is now the U.S. Solicitor General speaking. Before, the other lady was the advocate for the abortion clinic. So different women. So we've moved on anyways. But incidentally, this either proves that she's smarter than me or she's more well-prepped than me. Because, it seems like the natural answer to this question is yes. It's like, you want to say yes, right? Because we're talking about Plessy versus Ferguson, right? So we're talking Plessy versus Ferguson, 1896. Plessy versus Ferguson, 1896. Wouldn't be overruled till Brown versus Board, which was what, about 50 years later, give or take? All right? So Alito here is like, okay, What if it was argued in 1897? What if someone came back in 1897 and argued the case? Could you overrule it merely because it was egregiously wrong? Like, nothing's changed factually, right? Between 1896 and 1897, nothing's changed. Nothing of substance is going to change this analysis, right? It's like, it would be very hard to imagine that anything of substance is going to change between 1896 and 1897 that would change this. So she asked, well, can you overrule it for being just materially awesomely wrong, right? And the natural answer you want to give is yes. But then, of course, if she says yes, then she has a problem here, right? Because then they can say, well, this is just another example of a clearly egregious decision. It's another reason, right? She's another reason. So I don't know whether she's well-trained or she's smarter than me, but she gives the much better answer of no. So even though, like, probably every instinct in her body really wants to say, 1897, they really should have overruled Plessy if they reheard that case. She can't make that concession without weakening herself. So she bites the bullet. She bites the bullet and says, yeah, I can't concede that ground. It's a smarter answer, and, again, props for seeing it. Props for seeing it.
That the decision was wrong. It has always applied the stare decisis factors and likewise found that they warrant overruling in that instance. And Casey did that. It applied the stare decisis factors. If stare decisis is to mean anything, it has to mean that kind of extensive consideration of all of the same arguments for whether to retain or discard a precedent itself is an additional layer of precedent that needs to be relied on and can form a stable foundation of the rule of law.
General, you've talked a number of times about the reliance interests here, and I think I'd like you to say a little bit more about that, because, sometimes when we talk about reliance interests, it's like there's a rule of law, and you look at it and you say, oh, somebody will enforce my contract because of this rule, and it has a very kind of grounded quality to it. And as Casey talked about the reliance interests here, they're a little bit more airy. And I just wanted to get your sense of what are the reliance interests here, and how do they cash out on the ground?
Well, there are multiple reliance interests here, as I think Casey correctly recognized. Casey pointed to the individual reliance of women and their partners who had been able to organize their lives and make important life decisions against the backdrop of having control over this incredibly consequential decision whether to have a child. And people make decisions in reliance on having that kind of reproductive control, decisions about where to live, what relationships to enter into, what investments to make in their jobs and careers. And so I think on a very individual level, there has been profound reliance. And it's certainly the case that not every woman in America has needed to exercise this right or has wanted to, but 1 in 4 American women have had an abortion. And for those women, the right secured by Roe and Casey has been critical in ensuring that they can control their bodies and control their lives. And then I think there's a second dimension to it that Casey also properly recognized, and that's the societal dimension. That's the understanding of our society, even though this has been a controversial decision, that this is a liberty interest of women. It's the case that not everyone agrees with Roe versus Wade, but just about every person in America knows what this court held. They know how the court has defined this concept of liberty for women and what control they will have in the situation of an unplanned pregnancy. And for the court to reverse course now, I think would run counter to that societal reliance and the very concept we have of what equality is guaranteed to women in this country.
It is certainly true that there can be some planning by some people about pregnancy. People who are raped don't have a choice, whether it's by an outsider or their own husband. And not everybody can afford contraceptives, contrary to your adversary's brief. In fact, 19% of the women in Mississippi are uninsured, so they don't have money to pay for contraceptives. So, but why their point in their brief was, contraceptives, if you use them, the failure rate is very small, et cetera, how can there be real reliance? So could you address that issue?
Of course. So first, this is not a new circumstance. Since Roe and Casey, contraceptives existed in 1973 and in 1992, and still the court recognized that unplanned pregnancies would persist and deeply implicate the liberty interest of women. But I think even on the facts, the state is mistaken here. A contraceptive failure rate in this country is at about 10% using the most common methods. That means that women using contraceptives, approximately 1 in 10 will experience an unplanned pregnancy in the first year of use alone. About half the women who have unplanned pregnancies were on contraceptives in the month that occurred. And so I think the idea that contraceptives could make the need for abortion dissipate is just contrary to the factual reality.
You also mentioned, or maybe it was your co-counsel, that life changes for women after 15 weeks.
That's exactly right, Justice Sotomayor, and I think that this is responsive as well to the questions that the Chief Justice was asking about, in particular, the impact of enforcing a 15-week bar in this case. The court has always looked at that issue by looking at the people for whom the law is a restriction, not those for whom it's irrelevant. So the question is, why would women need access to abortion after 15 weeks, and what is the effect on them? And there are any number of women who cannot get an abortion earlier. They don't realize that they're pregnant. That's especially true of women who are young or don't have an experience. Of course. So first, this is not.
I'm sorry, I missed it when it was said because I was too busy fighting with YouTube. Contraceptive failure in this rate is about 10% using the most common methods. I don't know about that one. Seems a little bit off. Why would women need access to abortion after 15 weeks, and what's the effect on them? And there are any number of women who cannot get an abortion earlier. They don't realize they're pregnant. Well, some people are giving birth before they realize they're pregnant, which, it happens. There's a whole TV series on it, didn't realize I was pregnant. So, I don't know.
Lose their job, or their relationship breaks apart, or they have medical complications. Or for many women, they don't have the resources to pay for it earlier. It takes time for them to raise the money or make the appropriate logistical arrangements to be able to take time off work and travel and have childcare. And for all those women in this category who need access to abortion after 15 weeks, the fact that other women were able to exercise their constitutional rights does nothing to diminish the impact on their liberty interests in forcing them to continue with that pregnancy.
Thank you.
General, following up on that, would that argument be true in terms of viability as well? In other words, your discussion of the reliance interests and the ability of women and men to control their lives in reliance on the right to an abortion, the argument would not be as strong, I think you'll have to concede, given what we're talking about, which is not a prohibition. It's a 15-week line. Is that right?
Yes.
You have to hypothesize people who have planned their lives according to a 24 or whatever week limit it is, but not a 15-week limit on abortion, right?
Well, I don't think the court has ever analyzed reliance with that kind of parsing. I think here the force of the viability line is that it's clearly demarcated the scope of a woman's protected liberty interest in this context. And the state is not actually asking this court to replace it with a clear 15-week line that would provide some measure of continued protection for this right. They're asking the court to reverse the liberty interest altogether or leave it up in the air. And if that were to happen, then immediately states with 6-week bans, 8-week bans, 10-week bans, and so on would seek to enforce those with no continued guidance of what the scope of the liberty interest is going forward.
Well, that may be what they're asking for, but the thing that is at issue before us today is 15 weeks. And I just wonder what the strength of your reliance arguments, which sounded to me like being based on a total prohibition, would be if there isn't a total prohibition. And as far as viability goes, I don't see what that has to do with the question of choice at all.
Well, I think as Casey emphasized in reaffirming the viability line, the court justified that as having both a logical and a biological justification, that it marks the point in pregnancy when the fetus is capable of meaningful
life.
That's
what John Hart Ely explained was a complete syllogism. That's the definition of viability. It's not a reason that viability is a good line.
Well, it's focused on the idea of fetal separateness.
Let me just see what that was a little bit more. Just wonder what the strength of your reliance arguments, which sounded to me like being based on total prohibition, would be if there isn't total prohibition as far as viability go. I don't see what has the question to do with choice at all. Casey emphasizes in reaffirming viability line, the court justifies that as having both logical and biological justification that marks the point of pregnancy when the fetus is capable of meaningful life. That's what John Hart Earl Ely explained was a complete syllogism. That's the definition of viability. It's not a reason viability is a good line. Maybe it's just me, and it's not quite clicking in my brain. But I don't know, something about that exchange just seems a little bit hard for me to parse. Maybe it's just a me problem though. So let's press on.
And I think that that is a line that also accords with the history and tradition in this country of abortion regulation. Contrary to the state's arguments here, at the time of the founding and for most of early American history, women had an ability to access abortion in the early stages of pregnancy, and it was only when the fetus was deemed sufficiently separate the states could act to bar that. So I think that the viability line also aligns with history and tradition in that respect.
Justice Thomas?
You heard my question to counsel earlier about the woman who was convicted of criminal child neglect. What would be your reaction to that as far as her liberty, and whether or not the liberty interest that we're talking about extends to her?
Well, Justice Thomas, I have to confess that I haven't read the specific case you're referring to, but if I understand the question you were posing, it sounds as though the state is seeking to regulate for a child that's been born that was injured while it was inside the womb. And I think that we are not denying that a state has an interest there. We're not denying that a state has an interest here either. Roe recognized that states have interests that exist from the outset of pregnancy. But with respect to this specific right to abortion, there are also profound liberty interests of the woman on the other side of the scale, and not being forced to continue with a pregnancy, not being forced to endure childbirth, and to have a child out in the world. And the state's arguments here seem to ask this court to look only at its interests and to ignore entirely those incredibly weighty interests of the woman on the other side.
Thank you.
Justice Breyer? Justice Lee? No? Justice Gorsuch? Any further?
I just want to make sure I understand your response to the Chief Justice. If this court were to reject the viability line, do you see any other intelligible principle that the court could choose?
Well, I think that it would be critically important, even if this court were to reject the viability line, to reinforce and reaffirm the fundamental and profound liberty interest at stake here. And
I'm sorry for interrupting, but that wasn't my question. I understand that point fully by the end of this argument. That is deeply clear to me. I understand your position. I'm just asking a question about whether you think there would be another alternative line that the government would propose or not. You emphasized that if 15 weeks were approved, then we'd have cases about 12 and 10 and 8 and 6. And so my question is there a line in there that the government believes would be principled or not?
I don't think there's any line that could be more principled than viability. I think the factors the court would have to think about are what is most consistent with precedent, what would be clear and workable, and what would preserve the essential components of the liberty interest. And viability checks all of those boxes and has the advantage as well as being a rule of law for 50 years.
Thank you. That's helpful, counsel. Appreciate it.
Justice Kavanaugh?
You make a very forceful argument and identify critically important interests that are at stake in this issue. No doubt about that. The other side says, though, that there are two interests at stake. that there's also the interest in fetal life at stake as well. And in your brief, you say that the existing framework accommodates, that's your word, both the interest of the pregnant woman and the interest of the fetus. And the problem, I think the other side would say, and the reason this issue's hard, is that you can't accommodate both interests. You have to pick. That's the fundamental problem. And one interest has to prevail over the other at any given point in time. And that's why this is so challenging, I think. And the question then becomes, what does the Constitution say about that? And I just want to get your reaction to what the other side's theme is, and I've mentioned it in my prior questions. When you have those two interests at stake, and both are important, as you acknowledge, why should this court be the arbiter rather than Congress, the state legislatures, state Supreme Courts, the people being able to resolve this? And there'll be different answers in Mississippi and New York, different answers in Alabama than California, because there are two different interests at stake, and the people in those states might value those interests somewhat differently. Why is that not the right answer?
Justice Kavanaugh, it's not the right answer because the court correctly recognized that this is a fundamental right of women, and the nature of fundamental rights is that it's not left up to state legislatures to decide whether to honor them or not. And it's true different rules would prevail throughout the country if this court were to overrule Roe and Casey, but what that would mean is that women in those states who are refusing to honor their rights and who are forcing them to continue to use their bodies to sustain a pregnancy and then to bring a child into the world will have no recourse other than to travel if they're able to afford it, or to attempt abortion outside the confines of the medical system, or to have a child even though that was not the best choice for them and their family.
Thank you.
Justice Barrett?
I have a follow-up to Justice Kagan's question about reliance. I'm just trying to nail down, and I asked Ms. Rickleman this question too, but I'm not sure that I fully understand the government's position or Ms. Rickleman's position. So on pages 18 and 19 of your brief, you talk about reliance interests, and you quote some of the language from Casey about a woman's ability to participate in the social and economic life of the nation. And I mentioned the safe haven laws to Ms. Rickleman, and it seems to me I fully understand the reliance interests. They're the airy ones Justice Kagan was referring to, and then there are the more specific ones about a woman's access to abortion as a backup form of birth control in the event that contraception fails, so that she need not bear the burdens of pregnancy. But what do you have to say to petitioner's argument that those reliance interests do not include the reliance interests of parenting and bringing a child into the world when maybe that's not the best thing for her family or her career?
I think the state is wrong about that, and I think where the analysis goes wrong in reliance on those safe haven laws is overlooking the consequences of forcing a woman upon her the choice of having to decide whether to give a child up for adoption. That itself is its.
I don't quite buy this. The analysis in reliance on safe haven laws is overlooking the consequences of forcing a woman to have to decide whether to give up a child for adoption. But with abortion in place, she's forced to have to make a choice about whether or not to have an abortion. So how is it fundamentally different? Like, right? I mean, under the scheme we have right now, she's forced to decide whether or not to have an abortion or have the child. If we switch that to whether or not to give the child up for adoption or not, why is that a harder or fundamentally different decision? That seems a little odd to my mind.
Own monumental decision for her, and so I think that there's nothing new about the safe haven laws, or at least nothing new about the availability of adoption as an alternative. Roe and Casey already took account of that fact, and I think that there are certainly, of course, all of the bodily integrity interests that we've referred to, but also the autonomy interests retain in force as well.
Okay, so it's the reliance interests in the right to be able to choose to terminate the pregnancy rather than having to terminate the parental rights.
I think that is part of it, yes. And I think for many women that is an incredibly difficult choice, but it's one that this court for 50 years has recognized must be left up to them based on their beliefs and their conscience and their determination about what is best for the course of their lives.
Thank you, General.
Thank you, General. Rebuttal, General Stewart.
Thank you, Mr. Chief Justice. I'd like to do my best to make 3 points. First, picking up where you just left off, Justice Barrett, on safe haven laws. The respondents in this case, I believe, as Your Honor pointed out, have emphasized parenting burdens being a lead or the lead reason that women seek abortions. I would emphasize safe haven laws, as best I've been able to find, first came into existence in 1999 in Texas. They're now ubiquitous, and you're correct, Justice Barrett, that they relieve that huge burden. I would also add that as to burdens during pregnancy, I would emphasize that contraception is...
Erica asked me in chat, one involves having a biological child in the world and the other doesn't. Are you being willfully daft? I don't think so. At least not willfully daft. I might be daft, but not willfully so. It's just, it seemed a little odd to me because they're asking, okay, let's, talk about safe haven laws. So for those of you who might not be familiar or not from the United States, every state has a law that if you leave your child in a certain place, that you can't be charged with child abandonment or any other crime, like you give up your child just by leaving them in the place. And for example, typical places, although your state law may vary, would be like a hospital, fire station are very typical, but again, consult your state laws if you're looking into this option. And also they have different time periods, but whatever. So they said, okay, she said, well, why is that not sufficient? And the answer was because making the decision about whether or not to give your child up for adoption is really, really hard. And I'm like, is that really fundamentally harder than deciding whether or not to keep or abort the baby? Is that a fundamentally more difficult decision than whether or not to keep the baby in the first place? Because I would think, the termination of life would, if anything, be harder. So it seemed like a prudent question to me. So I don't think I was being unintentionally daft. So no, I'm not sure if anything I'm saying is making any other sense. Erica says, would it affect you to know you had a child out there somewhere? Now imagine you seeing an abortion at 10 weeks simply as not creating a human. Just try on that perspective. Okay, fair enough. That's reasonable. That's a fair point. So if you, that makes logical sense, Erica. Fair enough. So if you really believe having a child up to X weeks is not terminating the life of an entity with rights that are worthy of moral consideration, then I guess it would be logically easier, because at that point it'd just be like having a tumor removed. You're removing something that doesn't have independent moral consideration. So I guess, that would make logical sense. If you really believe that an abortion is removing something that has no moral consideration, then I guess that would be a lot easier than, deciding to give up your child when they have moral considerations. So, okay, fair point. All right.
More accessible and affordable and available than it was at the time of Roe or Casey. It serves the same goal of allowing women to decide if, when, and how many children to have. And I would also note, just frankly, the lowest cost abortion at Jackson Women's Health is $600 for the abortion.
I don't think this answer is very good, though. There's one answer from someone else in the chat that's not very good. Where is this? Because I thought it was kind of funny. Hold on, I gotta find this chat because it struck me as funny when I saw it. Okay, yeah, this struck me as funny. Blue-footed pig said at Uncivil Law, without knowing where your child is, you could be living them to be abused. There's lots of abuse in the foster care adoption system. That strikes me as very, very humorous, blue-footed pig. Yeah, I suppose it's possible that without knowing where my child is, that they could potentially be abused in the foster care system. But if the alternative is, ending the life of an entity with moral consideration, then I'm not sure about that one, man. I don't think that's a particularly good argument on that one, man.
Additional costs and further fees. According to my friends, the respondents and their amici, there are also additional costs related to travel, taking off time off of work, accommodations, all of those sorts of things. Whether somebody is uninsured or not, the costs of contraception are consistently significantly less than those. Number two, I think Justice Kavanaugh, you had it exactly right when you used the term scrupulously neutral. I think that's a very good description of what we're asking for here. I think it's the problem and the value that has evaded the court and will continue to evade this court under Roe and Casey. But that is exactly right. This is a hard issue. It involves, and I would emphasize, Your Honor, that, as you said, there are interests here on both sides. There are interests for everyone involved. This is unique for the woman. It's unique for the unborn child, too, whose life is at stake in all of these decisions. It's unique for us as a society in how we decide, if the states get to legislate on this issue, how to decide and how to weigh these tremendously momentous issues. In closing, I would say that in his dissent in Plessy versus Ferguson, Justice Harlan emphasized that there is no caste system here. The humblest in our country is the peer of the most powerful. Our Constitution neither knows nor tolerates distinctions on the basis of race. It took 58 years for this court to recognize the truth of those realities in a decision, and that was the greatest decision that this court ever reached. We're running on 50 years of Roe. It is an egregiously wrong decision that has inflicted tremendous damage on our country and will continue to do so and take innumerable human lives unless and until this court overrules it. We ask the court to do so in this case and uphold the state's law. Thank you, Your Honor.
Thank you, General. Counsel, the case is submitted.
The New York Times had an op-ed to make the exact... this is from Watchmaker 42. Watchmaker 42 says, the New York Times had an op-ed today make that exact point about adoption being worse than abortion for a child. Okay. That seems like a strange proposition to me, but I guess someone somewhere believes that, which seems odd, but okay. I mean, all right. Fine, I guess. It seems strange to me. Anyways, let me give you my summary of the case and my overall thoughts, and then of course I'll read your super chats and go through some of why are the lawyers called general? Because they're Solicitor General. Yeah, that's why they're called general, because they're from the Solicitor General's office. So they're called general. Because they're Solicitor General, that's why. Anyways, let me give you my overall thoughts. First of all, I really liked all three advocates. I thought all three advocates were really, really good and really, really sharp, which for anyone who's familiar with our Supreme Court React series knows is definitely not a guarantee. On more than a few occasions, we have been confused, mystified, and strucken into silence with the apparent inadequacy of some of the lawyers that have been arguing some of the cases. But that wasn't true today, my friends. In my humble opinion, I think all three attorneys were very, very good. I think all three attorneys were arguing very, very competently for their sides and for their positions, which is what an attorney is supposed to do. Right? They're all trying to defend their client's position. And they're doing it exceptionally well, to my mind. They know the law, they know the cases, they've got an answer to pretty much every single question. They know it backwards and forwards, up and down and every other way. And I thought all three advocates were really, really good. I thought all three advocates did pretty good job. I mean, better than pretty good. I think all three did good jobs in arguing their case. I didn't feel like any one of them was notably better than any of the other two, to be quite honest. I thought all three of them were pretty evenly matched, and all pretty evenly matched at high tiers. So, I thought this was a really, really solid argument, so that's really good. Thoughts on the case? I mean, Roberts obviously is trying to look for some middle ground, right? Roberts trying to look for some middle ground. It's like, can we get to this 15-week number? Can we adopt a 15-week number instead of just overruling Roe and Casey? Can we just adopt a different line at 15 weeks? So he's, trying that idea out, which doesn't really seem to be working because no one else asking questions that seems to, no other question seems to really rely or pick up on that idea. So it seems like Robert's idea for some sort of brokered settlement at a week cutoff, which is a little bit better than viability, at least in terms of a judiciable standard. Because viability, you have to get a doctor to determine if the fetus is viable, and that's going to be a little bit of a medical judgment call. If you just go to a week standard, then it's a little bit less medically ambiguous, although I guess you could still argue about how old the fetus is, but at least you have a better idea. And so I think it's 15 weeks is obviously a little bit more solid as a concept, even if it's than viability, because viability is a little bit harder too. Because again, are we talking about viability in all the cases, viability in a majority of the cases, viability in one case? What exactly are we talking about? So, viability as a standard is a little bit meh. So I think that the I think we're looking for some fairly serious modification of Roe and Casey. So maybe we're just looking for another Casey. Casey was a pretty significant modification to Roe. So maybe we're just looking for some serious modification to Casey in the same sense, although perhaps in a different direction. We're looking for establishing some sort of new line and maybe redoing what undue burden is, because that's been a little bit tricky to define. So maybe we can clean it up and make it better. So that's a possibility. But, there's also a strong possibility. There's also the possibility that we just overrule Casey completely, get rid of Casey, and just build something new on top of Roe. So rather than try to modify Casey, we just get rid of Casey completely and replace it with something that will sit on top of Roe, which also has nice advantages. We could also, of course, go all the way and strike down Roe and Casey and then come up with something completely different again, which could be basically anything. The most what do I want to say? The most conservative? I don't know if that's the right word in the sense, but I got nothing better. The most conservative proposition would be for them to say, it's just up to the states and let the states decide and do whatever the hell they want. And maybe Congress or maybe not. And incidentally, if Congress tried to pass a law on this that superseded the states on this issue, I'm not 100% sure that works under Federalist principles. So in the event that they leave this up to the states, in the event that some Congress now or in the future tries to pass a law to overrule this and make it a national issue, that itself will be one hell of a case as we go through the federalism issues. And I'm not so sure about that one at all, because there's an enumerated powers problem. Normally we get everything under interstate commerce, but trying to put this under interstate commerce, man, that is one hell of a bad fit. Let's regulate abortion under interstate commerce. Abortion, yeah. Pregnancies are now commerce that we can regulate. That's a tough squeeze, man. That's a tough squeeze. You can say, well, having babies has economic consequences, so we can regulate that way. But I don't know, man. That's not really solid enough for me. I'm not really buying this one under Commerce Clause doctrine. It seems no. And trying to find a different place to hold this under seems really, really difficult. So, I'm sure Congress will eventually try. I'm sure there will be eventually a lawsuit over it. but I'm not really sold on that one. So I think then we'll just be a patchwork of 50 states, and some states will have all the abortion forever, and some states will have no abortion, and some states will be somewhere in between. And I guess we'll see how that works. So, that'll be fine. I think if anything, Roe was fundamentally pragmatically wrong. So whether or not you think it was legally right or legally wrong, I think it was pragmatically wrong. It was not ripe for the decision at that time, as opposed to Obergefell. So let me give you what I'm talking about. At the time the Supreme Court decided Obergefell about gay marriage was legal in I don't know how many states, but lots. The vast majority of states had gay marriage or gay partnerships or something. And if you looked at polling, right, based on it, like acceptance became more and more accepted, and more states adopted, right. So by the time the Supreme Court eventually comes in and pops in their head, I don't know what the number is, but such a significant number of states had it already that it didn't seem that much to go from whatever was there to all the way, right? So it didn't have a pragmatic problem. The biggest problem with Roe versus, well, not the biggest problem, but a significant problem with Roe versus Wade is at the time of Roe, if memory serves correctly, and I'm pretty sure I'm correct, I think 4 states had a right to an abortion. And obviously the rest didn't. So I think it was pragmatically wrong. It's like, even if it was legally wrong, the problem was the vast overwhelming majority of the country wasn't there. They weren't there. And you said, well, these 4 states, we're going to take that and we're going to apply that throughout the United States, which is, and it froze that, I think, anger and animus in place. So I think the Supreme Court made a major mistake in deciding Roe when it did, assuming that was the right decision, which again, but they killed the political debate by making it a constitutional issue. They completely killed the political debate. And who knows how that would have proceeded, had it been allowed to proceed. Maybe it would have been like the gay marriage debate. I wouldn't know for sure, but I would think that the approval rate of gay marriage and the approval rate of abortion, if I were a betting man, I bet they were roughly the same in 1973. Not strongly popular propositions. I think they're probably not greatly popular. So, maybe if the states had been allowed to experiment, maybe, it would have been the case that they would have been adopted voluntarily by the vast majority of states and eventually adopted by the Supreme Court, and there wouldn't be all this huge resentment and so forth and so on. So I think that's the real practical impact. And Elgin says we're still not there. One of the reasons we're not there is because we haven't had the opportunity to have the political debate, right? It's all been frozen in place. We've not been allowed to have the debate for 50 years. The Supreme Court took away the damn debate, man. They took it away from us. We haven't been allowed to really work it through and really try different things and see what works and see what doesn't work and really, stick to our principles and see how it really works and all the stuff. So, we haven't been allowed for 50 years to really have the debate. We've been having the debate, in sort of the zeitgeist, but not within the legislatures. We've not been having the states try different things, and the laboratories of democracy not been trying different things. We're still frozen in place for 1973. So I think that's a real problem. So I think that's a real fundamental, real politique problem. And I think for the same reason, it's no matter what the Supreme Court does here, if they reverse Roe or not, it's going to be the same problem, right? Because we've frozen it in place, and now everyone's in a state of chaos, and it's going to take us some number of years to work through those issues, assuming they can be worked through. And in the meantime, we have a patchwork of states with various things and blah blah blah, all that great stuff. So it's gonna be a problem. It's gonna be an issue. So that's sort of what I think on the whole issue. So I think the most likely outcome I think that Casey probably goes away. I think Casey versus Planned Parenthood probably goes away because it's a completely fractured nightmare mess. Casey versus Planned Parenthood is a fractured nightmare with 20 opinions or whatever it is, and you do have the one opinion for here's the importance of precedents, but as to substantive issues, it's one of those cases where we have to cobble together things, and suddenly we're under a Marx doctrine, and oh my god. So I think Casey needs to go away on just purely pragmatic reasons, because the case is a mess. So you could replace it with something basically identical, but you just have to get a something that's not quite so split. So I hope whatever we get out of the Supreme Court, we get an actual majority on the substantive stuff, and we don't wind up with one of these fractured nightmare opinions that I have to start counting votes, because that makes me sad. And not only makes me sad, but makes all the lawyers sad, and even perhaps more to the point, makes all the judges sad as they try to figure out what the hell it's talking about. So it's like a nice clean opinion would be great, but I think Casey goes away. And then what happens, whether or not they'll take over Roe, and then what do they do with it? It's like, well, do they just simply say 15 weeks? Do they say, it's a state decision, will be, and, watch the protests go on, and how will that affect the November elections, and so forth and so on? So, in terms of when this will be decided, the Supreme Court term ends on the last day of June 30th. So, except in exceptionally rare circumstances, and it happened once relatively recently, in the last couple of years. But, and I think in that case, the debate argument was later in time. But, short of that, where the order of re-argument, which is exceptionally rare, you would need a decision before June 30th. So where before June 30th, your guess is as good as mine. One would imagine this is going to be closer to June 30th than not. For various historical reasons, the more controversial decisions, it's more likely to be granted. But maybe this one will come earlier to let the political blowback try to resolve by the time of the election or something. So when will this come down? Your guess is as good as mine. But, could be anything. Could be tomorrow. It won't be tomorrow, but it could be tomorrow. Or it could be June 30th, or somewhere in between. Or, the Supreme Court decides to punt the whole thing, order re-argument in the fall again, and then do something. Which, yeah. So those are your sort of possibility outcomes. So let's do some super chats, and let's do some other chats that have been brought up by you. And thank you, as always, to all you guys who are supporting me. Thank you to the 906 of you who are currently still watching. It's been awesome. And we did get above 1,000. Thank you. Okay. Let me take a look. Okay. Let's see. $50 from Rogue Accountant. Thank you. That's very, very nice of you, by the way. I just saw that pop up right now. Let's do the rest of the super chats. Do all the super chats. $4.99 from Johnny Stoffel. If women only gave oral arguments, we might not need Roe versus Wade. Funny. Super chat from $5. To Truth for Liberty. Prediction. Supreme Court will affirm as it should that viability remains the constitutional line. I do not think that is likely, my friend. I do not agree with you. $5 from Bill Taldy. Plurality opinion to overturn Roe and Casey by Thomas. 2-3 join. Concur by Roberts. 1-2 join. Viability. Concur by Gorsuch with Thomas. 9th Amendment. 3 dissents by liberals. Chaos. That could well be true. Super chat 1776 from To Truth for Liberty. For stare decisis to successfully fill its critical role function, that analysis should only allow the rarest of cases to be overturned. That's a perfectly valid opinion. To Truth for Liberty. It's a perfectly valid opinion. Super chat $10. Mike Maestro 13. Excuse me. Excuse me. See you in Racket Stream. I think you have pretty good views. In my view, the core question is, when is a life a life, and when does it have the same protections as other life? I think the second question is better. Or I think slightly better than that is when does this entity, which is human life, from the moment of fertilization, because like what else could it be? It's obviously living, it's obviously human, so it's human life from the moment of fertilization. That's just biological reality. So the question is, when does this human life have moral weight? And when, if ever, does that moral weight become greater than or than the mother's moral considerations? $5 from Mandalore Wise. The SCOTUS picks doesn't help the mental image of Karen with power here. $5 from Z. Michael Galik. The relevant question is not when life is life, but rather who decides that, the court or the legislature. I'd argue the legislature. $5 from Super Iron Bob. I only believe this line of reasoning from Sotomayor if she would allow me to have my Schedule II medications prescribed without government interaction. Preach that, brother. Preach that. $5 from Tall Skinny Geek. Merely raising these issues brings you into the political realm. The Constitution definitely doesn't prevent the government from hurting poor people. That's true. I mean, the Supreme Court has directly ruled that poverty is not a protected class, so yeah. $4.99 from Jacob Papa of 6. 75% of women that are 75% poor are poor. $5 from Jacob. I assume Sotomayor meant 75% of the stats cited by the Supreme Court justices are made up themselves. $5 from Body Blah. Over under on Roe finally getting overturned. I think there's a very good chance that Casey gets overturned. So I'd put it probably for Casey getting overturned at maybe 75%. For Roe getting overturned, I think it's less likely than not, but certainly not unlikely. So I put it at 33%, 1 in 3. $4.99 from Johnny F. Face. Isn't this the same lawyer who was tracking young girls' periods when she ran the Office of Refugee Resettlement? Don't know. Might well be. $5 from Britt Cormer. I'm not a fan of looking to international law for abortion because I'm not a fan of looking at international law for the Second Amendment. I think that's fair, but I think they weren't looking to it for the law, but the impact as a factual matter, or at least that's how I understood it. $5 from Skyheim. I need invoice of lawyers as your backdrop. No. $5 from Bobby Salunt. The earliest a baby has been born and survived is 21 weeks and 5 days. $15 from Mandrake. Even if someone is not religious, I find all this disingenuous. We'd rather freak out the notion of terminating unborn dogs and cats rather than spay or neuter. Why not just go that route for humans? $4.99 from Professor Chaos. I'm late to the party. Start at the beginning, but Paul Clement is a former Solicitor General and the guy you went arguing your case at SCOTUS. Paul Clement is GOAT. But these guys were very, very solid. $2 from Clumsy Clairvoyance. This judge is wreaking havoc. Laughing my ass off. $10 Canadian from Curtis D. Does it matter to her point that viability is not the same for everyone? Wealthy in an urban hospital and poor in a small clinic in a tiny town have different viability. Good question. $5 from Alpha Photographer. Thank you. $10 Canadian from Curtis D. Viability is only going to become earlier as science advances. What happens if someone invents an artificial womb? Doesn't that mean that viability is an untenable lie in the long term? $5 from Bloody Ba. Lawyers have to argue for the case in their hands. They can't think about the next case. They need to dig deep and argue specifically that case. Well, I'd partially disagree with you. I think lawyers have to think a little bit about the cases that follow, particularly at the Supreme Court, because the Supreme Court's going to be thinking about it, right? They're going to be thinking about what comes next, what comes next. So you probably don't have to think. You probably don't have to think about it at the trial court level. So I think that's fair. You probably don't have to think at all about what comes next at the trial court level. But I think you do on the appellate level, and you definitely do at the Supreme Court, because the judges who are hearing the case are thinking about it. And you should too. $5 from Z. Michael Galik. I think this case is fascinating. If you're on the pro-abortion side, you're tacitly endorsing 50 years of racism because, hey, process is important. $5 from Z. Michelle Gleek. You don't have a right to not have a child in the world. Just ask men. That's a fair point. That's a fair point, you know? Yeah, you don't have a right to not have a child in the world. Just ask men. That quest reeks of sexist privilege. I mean, fair point. So, reasonable. $50 from Rogue Accountant. I'm 2 hours behind you all, but love this episode. Thank you, Uncivil. Well, thank you very, very much, Rogue Accountant, for your $50 super chat. That's incredibly dangerous. Not dangerous. Incredibly generous. And really, really helps me. It really, really does. Because I want this thing to go pro. I cannot even begin to tell you how burned out at my job I am. I need to leave. And so things like that really, really help. Thank you very, very much. $2 from David Woman. I only do subpar chats. $5 from Katrina Dancer. We slaughter animals that are sentient. We care more about that than a non-sentient embryo. My religion, Abulgisian, doesn't allow procreation. Sue. Okay, fair enough. So let's see some of the chats that you have been making throughout the day. The cameraman says, how are we able to broadcast the Supreme Court but can't for Maxwell? It's a different court, and that's just the way it is. Johnny says, if government has a compelling interest in preserving the life of its potential citizen, could they use eminent domain principle and pay for the trouble of carrying the unwanted child? No, because you can't buy life. So no, but it's an interesting idea. I mean, they could do it for other reasons. Running with scissors. This seems emotional, not a legal argument. Or will be sooner comments. What's your take? I disagree. I disagree completely. I thought all three advocates were making exceptionally good legal arguments, and the emotional arguments were present to some degree, but I found them to be well controlled in all of the cases. Duck Pone says, will you be my friend? Sure. I like to think that I'm, on pretty good terms with everyone on the channel. And one of the reasons we say keep it civil. The law might be uncivil, but we don't have to be, right? Andrea Chari says, how do you feel about substantive rights under the Due Process Clause generally? Well, as to substantive rights under the Due Process Clause generally, I oppose them, but I oppose them in a way that doesn't really matter in the end, probably, because we have this perfectly workable thing called the Privileges or Immunity Clause. It was great. It's great. It's in Section 1 of the 14th Amendment, and it was great, and it was going to do all the wonderful things, and the Supreme Court kind of nuked it. They nuked it hard in the slaughterhouse cases in the late 19th century. And so then later, when the Supreme Court was looking for some way to incorporate it, what they could have done was, unnuke the slaughterhouse cases. But no. What they did instead was come up with this idea of substantive rights, which doesn't, substantive due process, which doesn't even make sense linguistically, substantive process. But that's what they did. So I oppose it, but I would just redo. I mean, fundamentally, I think it would probably come out exactly the same in the Privileges or Immunities Clause. It would just be a lot more intellectually pure. So, but then again, I like that intellectually pure stuff. So, $49.99 from Classy Mom. Thank you so much. Thank you for being willing to have a meaningful conversation when many steer from the topic. You are extremely welcome, Classy Mind. And as always, right? I just said, let's not make it personal, guys. Let's not make it personal. You can have any position you want. Let's just not insult people. Let's not inflame people, right? You can have any position you want. Just try to express it with a little bit of respect and care, so that with the chat doesn't deflame into a flame war, because I don't like that kind of thing, right? And we can have a respectful, meaningful discussion about these questions. That's a good thing. I think it's a good thing. And so, I'm glad the chat has largely been very polite. And I'm very glad that my mods have been helping me keep it very polite on such a sensitive topic. So, and all the people who've been complaining about censorship. It's like, first of all, I'm not the state, so whatever. And second of all, you can say in substance anything you like. It's just that you have to say it with, respect and kindness instead of inflammatory. So, rephrase. Just communicate the idea a little bit better. Erica Joe says, embryos are destroyed all the time in fertility treatments. Just something I think points to society viewing embryos and humans slightly differently. Fair. And Sandy Popper says, what do they mean by watershed? Basically, really, really important. Yeah, Andrew W. says, I'm trying my best, but discussions on ending life. Yes, it is, and that's all the more reason. That's all the more reason to treat each other with respect as we express different points of view. Yeah, it's all the more important as the subject becomes more important that we treat other people who might think differently with respect, and we try to persuade them, right? Being really, really angry and being really, really volatile and being insulting and being personal is not a good way to persuade people. It's not a good way to persuade people. So, I think it's fundamentally in your interest, regardless of what your position is, to treat people with respect and try to persuade them. If you treat people without respect, they're certainly not going to listen to you, at which point you're preaching to the choir, and, you're not helping my chat in any event. So, do that. Respect is earned, not given. Not on my channel, it isn't. Not on my channel, it isn't. I demand respect. I demand it from everyone. Everyone will respect everyone else in my chat, damn it. It's a mandate. Scorpion 142 says 50 years of law can still be wrong. How can you argue lower cases are scattered and don't know what to do, but cases like this always lose? Because these kinds of cases are really, really extreme, really, really extreme versions of it. If you're given the opportunity to address the Supreme Court, what case would you present? Oh, it would have to be some kind of gun case. That'd be super fun. Interesting. Mississippi refers to the position as solicitor. Not used to hearing that on the side of the pond. That's true, Melanie. That's true. You're not used to hearing the term solicitor on the side of the pond. That's correct. But yeah, to the best of my knowledge, every single state and the U.S. government calls the position of the person who advocates solicitor. So maybe it's just, it's a legacy term, I guess, but whatever. $10 from Baba Salon. What if the court picks a nobody wins position like 21 weeks currently because that's scientifically proven viability, but a moving date as science advances? That could be too, man. That could be too. Although 20 weeks would be a little bit more likely just because, nice round numbers. And also because, you want to probably pick a number that if you err, so that you actually get to 21 weeks because there could be some debate. So, but yeah, that's also a possibility to pick like something like 20 weeks. There's a lot of possibilities out of this thing, man. RSPCECT, Kurt, won't you sing it for me? Maldive 00 gives me $200. That is an incredibly generous super chat. Thank you, Maldive 00, for your $200 super chat. You are a model for others. Everyone be like Maldives. You're constantly fair-minded. You're consistently fair-minded and often funny. Thank you. I try to be. I try to be very, very fair. I try to be funny. all those things, all the good things. So, you get your chat pinned. I cannot apparently pin your super chat. Why can I not pin your super chat? That's bullshit. How can I not pin a super chat? That's bullshit. Damn it. C. Crutch says, do you think it should be a state's issue? From first principles, I certainly do. And then Cody Sams pointed out, in respect to other countries and how they treat their law, wouldn't a main argument be that in most countries in the world, these health services are free and pose no income barrier? That's a fair point. In response to your thing about Cal VG about walking through a school zone, there's no federal law on point. I believe it's only a state law offense, and I don't think so. Patriot says, where do you find the audio for these arguments? Either at the Supreme Court website or OYEZ, usually a day or two later. Jonathan says, is there a rule that they can't be drunk while hearing cases? Probably. Side question, who's your favorite Supreme Court justice, both conservative and liberal, who's nominated since Truman? Ooh, that's a good question. To find out that, I'm going to have to go look at a chart. Hold on. Let's take a look at a chart and find out who was judged when. So let's see. First of all, I have to know when Truman came into office, so hold on. Oh, he served from 1945 on. Okay, so since 1945. Who do we like since 1945? Okay. Let's see. Let's see. For liberal justices, because that'll be the harder one for me. White was pretty good, but he wasn't that liberal. Justice Black is also pretty good. Yeah, so it's either Justice Black or Justice White. That's kind of funny. For favorite liberal justice since Truman. I'm also a little bit fond of Kagan. I think that she'd make a good Chief Justice, to be honest. So I think I'm also a little fond of Kagan, currently serving on the court at the moment. For favorite conservative justice since Truman, I mean, the first thought goes to Scalia, of course, because I'm a big Scalia fan. I'm also, at the moment, a bit of a Justice Gorsuch fanboy. Before that, let's see. Maybe Justice Harlan in the 50s. Yeah, I think Kagan would make a good Chief Justice. I think she has the personality for it. I mean, the Chief Justice doesn't get any more votes than anyone else. You know, I just think that she'd be I mean, I don't like Roberts that much. I don't think Roberts is a particularly good Chief Justice, so that's part of the reason. So it's like, well, who on this court would be better than Roberts, right? And you need someone who, would be workable, and I think Kagan might be able to do it. So that's kind of my thoughts on that, And I think she has moments where has some pretty decent thoughts, so that's kind of the idea there. Rehnquist in his later years got way off for me. I mean, when Rehnquist first started, sure. When Rehnquist first started, but by the end, no. Andrea says, on a scale of 1 to 10, how amusing is it when she dodges questions? I don't know if she was dodging the questions or if she was just a little bit misunderstanding the questions, but either way, I thought them all to be very, very fair. But you heard it here first. Apparently, it doesn't matter if you're Justice Black or Justice White. Justice Black is pretty entertaining, just because he's an interesting character, man. Justice Black. He was hardcore, man. He was hardcore. Yeah, it might be Justice Black. Where's Justice Black on this chart? Let's see, where is Justice Black on this chart? I'm just trying to find him again on this little grid so I can find out where the hell he is on the ideological chart. Yeah, Justice Black. Yeah, Justice Black was pretty hardcore at times, man. I think it is Justice Black. Justice Black was pretty hardcore at times. He's preschool. Yeah, I think he's pretty cool. So he might be my favorite left-leaning justice since Truman. Yeah, I think it would have to be. Am I listening to Christmas music? Not exactly. There's just an open air bar that plays music. They have like a stage and everything. So that's just coming in from the street. So you gotta stick with that, Black was a member of the Klan. That I did not know. I just was basing it off his opinions. So I didn't know that little aspect. Basil Faulty 241 says, overturning this will be horrible for the country, but not because it's wrong to overturn it. It's because of the nature of the people who rely on its way currently. Okay, that's fair. And Alexander says, I think they have 5 justices to overturn completely, but one will go with Roberts because of possible backlash. Maybe. Watching it daily says, can they hold it till after the election? By ordering re-argument, they can. Are they writing their decision basically now, announcing it 6 months from now? They might very well be. Supreme Court, do they rule in the Texas heartbeat bill? No, they haven't. They also argued, so there's also the Texas heartbeat bill in Texas versus United States and whole women's health. So watch them announce all 3 abortion decisions on the same day, which would make logical sense because they're all interrelated. So science works in a mysterious way. Were you reading a super chat about needing to leave your job, or was that you? Though that was definitely me. That was definitely me saying I need to leave my job. I've been doing my job for 14 years. I'm very, very tired. I definitely need to leave. Watching Daily says, you're over 44,000 subs. Good job. Thank you very, very much for all the 44,000 of you who are subscribed. And it's very, very rewarding to see the channel grow so well. Blue-Footed Pig says, love your balanced, level-headed nature. Thank you. M. Gabriel says, can the parents be found guilty of the negligent homicide for not taking action? Possible. This is referring to the recent school shooting case. The parents have been charged with negligent homicide. It's possible. I read the press conference. I said, listen to the press conference. It seems like they have some facts that point in that direction. But then again, the school also knew about all those things and was also in a position to take action. So it's possible, and I'm definitely not ready to, proclaim anything beyond it's possible at this point. Do you think Dobbs and New York Gun Club will be decided on the same day? No, I think Dobbs, Whole Women's Health, and U.S. versus Texas will be decided the same day, though. David says there's already pinned comments smashing the like button. Fantastic. Thank you. The Gun-Free School Act of 1990 isn't federal, doesn't apply? I'm not sure. Yeah. Duck Pone says, do you think any of the TV court judges, such as Judge Judy, would make a good Supreme Court justice? I mean, Judge Judy, better known by her legal name as Judith Sheindlin, was a family court judge for 25 years before she ever became Judge Judy. So, I mean, you could do worse. Do I expect a 5-4 decision on this? I mean, something like that. Something like that's probably where we're at, yeah. $5 from... apologize. $51.50 for Genome. Well, here's going to Pro Uncivil. Always enjoyed your input in the advice of lawyers, registered trademark streams, and much respect for always seeking the facts in your arguments. Our demon-haunted world needs more of you. Well, thank you very much for your generous donation of $51.50, Genome. Super Chat $5 from Record of Exiles. The Jussie Smollett case feels like a reward for living through the last 2 years. It's nonstop comedy. Yeah, and now the attorney is before the press doubling down on the judge attacked me thing, though. So $5 from Maldive00. Recall the joke about Justice Black. He frightened blacks while wearing white robes. Then he frightened whites while wearing black robes. $5 from Val. I didn't know that joke, incidentally, but that's kind of funny now that I know the history of Justice Black, which I didn't know before. $5 from Valerie Neems. Do what you love. I love listening to all you guys. Thank you very much. $5 from Brando Commando. Do all the justices sit down and come to their conclusions in a group, or they talk individually and see who's on which side? That is a good question, Brando. That is a good question. So there's a conference day. There's a conference day at the U.S. Supreme Court, and and I think it's held once a week during their in session. I mean, I could check the calendar and see when it was, but let's say it's once a week, okay? Or maybe it's twice a week. It doesn't really matter, whatever. So there's a conference day, and that's the first time the justices discuss the case. So the 9 justices go into a room, and it's just the justices, famously. No staff, no helpers. And as is also a bit of lore, whoever the most junior justice is the one responsible for doing all the errands. So if they need something, then they'll go knock on the door and say something to a clerk. So if they want to contact a clerk, they don't call them or something. Right? The most junior justice, which in this case is Barrett, the most junior justice would get up and go to the door and just hand the clerk a note or whatever. And if the clerk needs to hand something to them, they knock on the door, and the most junior justice is the one that has to get up and go get the stuff. And as Justice Breyer, so Riley pointed out, he was the most junior justice for something like 10 years. So it was a long time gig as the pledge for Justice Breyer. But yeah, now that belongs to Amy Coney Barrett, so she's the one that has to go do that. It's just a little fun aside. Anywho, that's the first time they decide the case, or the first time they discuss the case. And let's see if I get this right. I don't remember if they do a separate speaking or a separate voting thing. If memory serves correctly, they talk about it, and they talk about it from most junior order on. So they start with most junior. I guess the idea is not to unduly pressure anyone who's been there from longer serving opinions. So in reverse order of seniority, they ask everyone their initial opinions, and you go from there. So and then usually at that point, they'll start assigning at least opinions tentatively. So whoever's the most senior justice in the majority assigns the opinion. So whoever that is, the most senior justice in the majority assigns the opinion. And you go from there and you start writing. And that's kind of how it works. $5 from Nuvi. I'm about 15 minutes behind, but respect is earned as a childish point of view. Disrespect is earned, respect is given. Fair. Basil Faulty says, jury's still out on Amy for me. Yeah, me too. We don't know enough about her yet. We don't know about her yet. So we don't know, but we'll find out. So that's kind of where we're sitting right now. This has been an incredibly wonderful stream, and I want to thank everyone from the bottom of my heart. This has been an incredibly wonderful stream in terms of super chats, in terms of support, in terms of viewers, in terms of the chat being very respectful on a tough topic. This has been a really wonderful stream, and we did cross briefly 1,000 viewers. We did cross very briefly 1,000 viewers, and we still have 700 people watching now. We still have 700 people watching now, and from the bottom of my heart, thanks to every one of you who is watching. If you haven't subscribed already, please remember to check the subscribe button. And even if you have subscribed already, check the subscribe button, because you never know. They might have unsubscribed you in the meantime. So if anyone out there is watching this and hasn't subscribed, please subscribe. I would like to make this continue to grow and continue giving out great content. I have so much great content for you guys coming down the pike. And I really, really appreciate all your support, and I really, really hope that this can be a full-time professional thing. Thank you to all of you. Please remember to like the video as well, because YouTube likes the engagement. Also remember to hit the bell. YouTube likes the engagement. Also remember that we now have a Patreon and a Locals. The link to Locals has been up on the screen pretty much the entire time. It's uncivillaw.locals.com, and you can help to support the channel. Locals is preferred over Patreon, so if you don't really care which it is, Locals is preferred over Patreon, but for the Legacy members, we also offer a Patreon option as well. You can show your support on that, and we're going to start having some wonderful games pretty soon. And yeah. Until later, my friends, I hope all of you are well. Until later, cheers and goodbye.